he support left the meeting.
Well, we
Looks
had
like you're
one.
live,
Now we got
Senator
another
Clemens.
one.
It
Okay.
looks
seem to
like
be
you're
live. You are now live.
Okay.
Okay. So I won't be able to give you assignments. Okay, committee. And we are live. This is Senate Finance. I now need to get back to my agenda. And before we started, even though it's going to take up some time, I feel compelled to say I have been puzzling. I had a call from the pro tem this morning who said she'd had several people contact her to say I was questioning her leadership and her ability, and I preferred the leadership style of her predecessor. I have no idea what I said that would make people feel compelled to talk to her, but I want to set the record straight. Other than the usual chair frustrations over time and the end of the committee, I have no problems. I stand in awe of anyone who could take over the responsibility of leading the Senate under normal circumstances, leading the Senate under pandemic circumstances and the huge influx of funding and regulations and everything else. I don't know what I said, other than all I can think of is I said no one had told me I had to get the miscellaneous tax bill out this week. However, that is my responsibility. I'm the one that's responsible for getting my bills out. So I just want the record correct. Also, the pro tem and I tend to deal with problems and concerns head on. If I have a problem, I'll tell you face to face. So with that, I'm going to go to surprise 360. And we'd hope to walk through. We are late because of technical difficulties, but I'm going to have Maria walk this through. We'll just keep pushing everything back. Walk us through this final version, just in case it's not completely final. And we'll have some time while we go through the rest of the agenda to make the final corrections. I did email with the chair of GovOps and told her we were interested in looking at the open meeting and laws and issues around that and the 3-person board. But then today, we just appointed a 3-person cannabis board. So I'm pretty sure GovOps dealt with that issue. We will either have to deal with, no, you can't talk to each other about business outside of a meeting, or we will have to appoint more members. Whatever happens, that can happen in conference, because that whole, we're different than the House, so that will be a discussion in conference. So Maria, why don't you pop it up on the screen and walk us, remind us what we did yesterday.
Okay, happy to do that. Maria Royal with Legislative Council. And just to be clear, some of the prior drafts that we looked at were just provisions of the bill in relevant part, the governance, the ARPA funded programs, and it didn't include other provisions in the House bill that you had not yet officially made a decision about. So this draft that I've just pulled up includes all of the language that you've agreed to so far. Any new language is highlighted, And it also includes the sections of the House bill that I don't think you've yet decided, whether you want to include them or not. So this should be a comprehensive draft strike all amendment. And we'll just start going through. I can run through the changes and then revisit, come back to anything that needs additional clarification. So the very first thing, I know we've walked through the findings and the intent section when we did the initial walkthrough of the bill. So there are about 6 pages of findings and intent. Obviously, I'm not going to read through them
Oh.
now.
I
When you're
did tell
ready,
Maria to
whether,
include that,
Yep.
but I didn't know there were 6 pages.
Well, and so if you're
No,
comfortable with these,
this is a big enough bill. I think it needs findings and intent. I mean, it's an important enough subject. They usually lay the reason we're doing this out there and what we hope to include.
Okay.
Let me raise a question early on with respect to findings, Madam Chair, if I can.
Yes.
We decided yesterday that we were not going to deal with the affordability issue in this particular bill. But should we not have a finding indicating that affordability and availability is a critical issue that the General Assembly needs at some point to resolve in order to ensure that there is in fact broadband availability for everyone?
Is that acceptable? Okay, I'm
I'm
doing the thumbs up, thumbs down system this day.
Senator Brock,
Yep.
The first finding, ensure that every Vermonter has access to reliable, affordable, high-speed broadband. And then we do ask the board for input. Does that cover it in your mind?
I don't know that it does. I think I don't know that that has the specificity of ensuring that people at the lower end of the income scale in Vermont are being thought about in terms of how to get them broadband. And I would just like to see something more explicit than that.
I think we need to acknowledge that even if we run the wire, there's still an issue with people being able to afford to get hooked up to the wire.
In other words,
Either-
having access is one thing, but having it is something else.
I think that's fine. We just need language.
Just in
Okay,
language.
well, we'll ask Maria to add that in. Is
okay.
that in the next? Yeah. Okay. So we've got that. Let's keep moving.
Okay, so section 2, we spent a lot on this. This is the new chapter on the Vermont Community Broadband Fund and Board. So I'm just going to go through new language. I've incorporated everything that I believe you've agreed to up until this point. So the first, so just kind of some technical conforming changes with respect to the board. And some substantive changes. So one, in terms of technical, I just deleted the reference to public members of the board and just refer to members because they're all public members. There aren't any ex officio members. In terms of substantive, I believe you'll see under subdivision 2A, line 6, that you wanted the governor's appointment to serve as the chair of the board. So that is now specified. And then I think Senator Pearson had raised the issue of staggered terms for a 3-member board. So the proposal here is a little different than it had been initially drafted for the 5 or 7-member board. And it specifies that the member first appointed by the governor shall serve an initial term of 4 years. The member first appointed by the speaker shall serve an initial term of 3 years. And the member first appointed by the Committee on Committees shall serve an initial term of 2 years.
And Madam Chair, I would just say Maria emailed me and said, any ideas? And this was one way to do it.
That works.
It was almost a placeholder, but I have seen this basic construct elsewhere.
No, that works. And the fact that we have the lowest chair might make it more palatable. The lowest time.
Yes, we're
Okay.
humbling ourselves. Yes.
That's right.
And so in
Right.
subdivision 4, just amended that language a little bit. I didn't show all the stricken language, so it's not to be too confusing at this point, but instead of, that they elect from among their own members, a chair and vice chair, you now have the chair already determined. They can elect a vice chair. The remaining member can be an officer, so that's still there. Probably more significantly, I do have another provision that specifies, which we'll get to, that the open meeting law, Public Records Act applies to the board and its records. But this language here that I included yesterday was what Sarah Cummings was talking about earlier, about, with the 3-member board, can 2 members confer, or to what extent should they be able to confer outside of an open meeting? And the language actually that I had here, I quickly had an exchange of emails with Tucker Anderson in our office, and there were some mixed signals. So what was put here, 2 members may discuss or deliberate the business of the board outside an open meeting consistent with. That actually doesn't make sense. If you want to have an exception to the existing statute, you can do that. My understanding is government operations might be taking a closer look at that. But the statutory references there, the cross references, are specific examples of what does not constitute a meeting, but they don't talk about discussing or deliberating the business of the board. So there's a little bit of an internal conflict with what I had written here. I just want to make sure that's clear. I did not want to leave that in the draft, but I understand this is something that GovOps may offer an opinion on for you to consider.
And we've now got the cannabis board, so we all should be probably following the same rules.
They are more akin to the Green Mountain Care Board. So they're
Yeah.
in that they're working full time, and I know the Green Mountain Care Board, this is a real problem for them. They can't basically chat and noodle things over except for in a live meeting. And anyway, are we officially asking GovOps to give us some help?
I exchanged emails and told the chair that we were interested in the open meeting section and the ability to talk. I also told her that we might have to make any changes. We live with what they tell us, or we'll have to get another member of the board in so that any 2 people are in a quorum. If
Well,
we
this is a
want-
kind of situation for a board to be able to have discussions on an ongoing basis. And I understand the importance of the open records law as well, but it's this kind of conflict that can potentially cripple the ability of this board to really operate other than in a very, very narrow fashion. And I am a little concerned about it. I hope that GovOps can give us some help. I mean, one option, I guess, could be to require them to wear body cams whenever they talk with each other.
Recorded. Yeah, I mean, there's a fine line here between the public's right to know and the ability of 2 people passing in the hall saying, geez, what'd you think of that testimony? And not have it recorded. So Senator Bray.
I'm guessing that the most important thing is when they're going to be approving like a plan of work or
Yes.
contracts and things like that. And so I suppose one way is to ensure that that kind of work is always done publicly, but
Sure.
conversational work prior to or after, otherwise it would seem incredibly hamstrung.
It is because of the size of the board. If we had 5 members, 2 members wouldn't be a quorum. And so they could have coffee and say, how are you feeling about this? Or, but with 3 members, 2 members are a quorum. So nobody can talk to anybody outside a public forum. And that does, as we're finding with Zoom, make it more difficult to move things along expeditiously.
Right.
Because
Well, even if
everything
we
has to be done.
expanded the board so that 2 people could talk, one, I think that seems like a very expensive and cumbersome way
Yes, it is.
to do it. And secondly, it still ends up having people dancing around the prohibition on a quorum. So you'd have to have 2 Zs keep talking until you covered everybody. I don't know. Could be a little crazy.
We'll let GovOps work on it. It's an ongoing issue just in society. So, but I think, Maria, you're right that what you read to us yesterday didn't just said you could all be at the same cocktail party, and it didn't, you didn't have to warn the city council 4th of July picnic. But it didn't really address what we were looking at.
Right.
Okay, so we'll keep going. We got the per diem.
Madam Chair,
Yes.
just Maria,
Okay,
are
per
you
diem.
going sequentially through here?
Yes.
Okay, I'm just looking at, I'm trying to look at your draft, trying to look at the screen and looking at the House Passed 360. And I see on page 7, they have a very nice statement of purpose. And I'm not clear about in a little c, it's section 2C. And I guess I'm wondering, rather than me flip around like a maniac, did we keep that in there or should we look at it? I'm picturing the conference committee, Madam Chair, and not wanting to negotiate things that we actually don't mind. You know what I mean?
Yeah.
I don't know. Maybe that helps us. I don't know.
That gives us something to see.
Yeah, so I didn't include that because I thought you were kind of doing a strike all and reworking section 2 entirely. But if you want to go back and revisit, so those were, there was a findings, purpose and intent sections that were specific to their authority. I think that's what you're referring to. And so if those make sense to you, we can go through those.
Well, I don't want to bog us down, but in our section 2, we have a section that's listed purpose, and we talk about the high level of funding. They just let me just read it, Madam Chair, if I could, and it's just one sentence. It is the purpose of this chapter to establish the Vermont Community Broadband Authority so we would change that, but to coordinate, facilitate, support, and accelerate the development and implementation of universal community broadband solutions. So, we might not say they were only CUDs in the House bill, but I don't know. Maybe it's superfluous, but it seems nice and clear, that language. And so I think it could fit in right in the second paragraph of section 2 here, right before the definitions.
Okay, is that, how does the?
I mean, it's not the most important thing. If people are frustrated, don't bother, but.
Seems fine to me.
Yeah, it's all right. Anyone?
Okay.
And we'll just have to make it, universal high-speed broadband instead of linking it to the CUDs necessarily.
Okay,
Thank you.
no problem. Now we are going to get down to, okay, so subdivision 7 under the board with respect to the Department of Public Service providing legal and technical resources. You had a proposal that was, I think, emailed to you for your consideration from the commissioner. And this would be specific authorization for the commissioner to hire one full-time employee to provide administrative services for the board, a limited service position, part of the classified service. And then also the commissioner is authorized to hire one full-time attorney to provide legal services for the board. This shall be an exempt position. And the salaries and benefits for these two positions shall constitute expenses that are to be reimbursed to the department from the fund. And you'll see the cross-reference to the fund. You already have as an eligible expenditure of the fund, both the board and the department's operational expenses.
The question I'd have on this is, this charges the commissioner with doing this. And we understand that the board is not up and running, and the chair and the executive director and so on are not hired at this point. But for subsequent rehires, it would seem to be that the executive director should be the one who hires these people when it comes to subsequent hires, as opposed to leaving the commissioner responsible for that indefinitely.
Now, well, I'm not sure how we've dealt with it, but I'm sure you all got the emails. Yesterday, we talked about there is the House bill set up giving out pre-construction, but they had no provisions for construction. And I was thinking, and we all got the email saying, well, we've got some projects that I think 3 or 4 CUDs sent email saying, well, we've got some things, you know, preliminary construction that we need to do. And so I'm saying, okay, we're going to authorize the commissioner or the department to do those as they did last year, but we haven't given them any staff to go through these new. So this would solve the initial problem. The commissioner could hire 2 people to help with the approval of the grants for this year. And then I think Senator Brock, you were saying subsequent.
In other words, once the executive director has been appointed, that those duties would fall to the executive director rather than the commissioner.
Okay. Yeah, in the interim, I think after, once the board is up and running, they should fall under the authority and control of the executive director and the board. And if they don't like them, they can fire them.
Madam Chair,
Yes.
I'm just wondering how these positions interact, because later in the draft, and I was scrolling through, I don't know if Maria, you can tell me where it is. We give the executive director the authority to hire at least 3 positions, I believe.
Yes.
So this would be 5 positions, which I don't have a problem with. I don't mind that, but I want to make sure, one, that we give them enough money, because I think we also limited it to 1.5 million for all administrative expenses, including staff, including the executive director. And also, to your point about they may be approving grants prior to the board being up and running, is it an administrative person and a legal person, the 2 people that we want them to hire first, or are there others? It's just the interaction between the other staff and this staff, I think, is important to make sure it works out. And we either need to be vaguer about it so they decide, or we need to be more specific about it, I think.
Okay, Senator Pearson.
Yeah, I think I agree with both Senator Brock and Hardy. We kind of have to commit to the board structure and the executive director. And so I think if we let the commissioner hire an attorney, but then shift it over under the board, that probably could be our solution there. And in terms of the staffing levels, sort of over the summer, Senator Hardy, the department has been giving out big chunks of money, of CARES money. So they had enough to deal with it in the short term. I agree that generally we haven't given them enough staff, but they've had enough so far. And so I'm not sure we need to solve that problem. So I would leave it there, I guess.
All right. So. This is all coming, I think, out of the discussion where we said that they would have access to the department's personnel or the department. And the commissioner has said, well, she doesn't have an attorney. And we had specifically talked about they have legal staff there and, administrative staff. She's come back and said, well, no, I don't have extra attorneys or legal staff. My attorneys are doing rate reviews for electric utilities. And so maybe what we do is strike this when we do the section on this year's prior to the boards being up and running and formed, giving the department, say they can hire or contract for whatever part-time services they may need. Then with the understanding that, because I don't think you're going to need I'm not sure you're going to need a full-time attorney. I think that's something going forward, the board or the director needs to decide. I think to approve the grants that are coming in, we'll just give them the ability to hire, is it part-time, temporary help or contract for services? You can contract for administrative services would probably be easier to switch over. I'm not sure you're going to need a full-time attorney, so allow her to contract for the services she needs to be paid out of the fund, with the understanding that once the board is up and running, these people would probably be first on the list to be hired, unless they were really bad. Senator Pearson.
I like what you're getting at, Madam Chair. So we would permit the commissioner to use some money for a contracted attorney. And then we've already, I believe, given the director the opportunity to hire an attorney or use money for contract legal, whatever. So maybe that takes care of it in the short term. We just make it clear some money can go to help the commissioner with legal duties or whatever.
Can use up to, I don't know, 100,000. We seem to throw that number around from the fund in order to hire
for
the
legal
staffing
and
she
other-
needs to get the grants out this year. And then the grants obviously come out of the fund. This is her
That makes
administrative
sense.
budget. Does that
make-
work? I'm hearing no one say no, so that works.
I think it makes sense as long as it's clear it's limited term employees. I think that it says limited term for legal and administrative, because there is some administrative work that needs to be done.
I'd say hire a contract for, because you frequently contract for things like auditors or attorneys you don't need on, expertise you don't need to have sitting on staff. I'm not sure she's, I mean, until these grants come in, nobody's going to know what you actually need. Oh, I have an email from the commissioner. Let me find it. If the commissioner's free, she can join us. Because this is an awfully awkward way. Okay. Okay, that came in, I think. She said they have been doing the CARES work on the emergency basis, and if they're going to, if they haven't done the work they're otherwise charged with doing in order to get the CARES money out, and she's going to need staffing. And if the commissioner is obviously listening, if this works, we'll just give her a budget to acquire the staffing she needs in order to get the grants out the door. Yes, Senator Bray.
Yeah, my impression was from different conversations with the department or that it was kind of an all hands on deck deal to deal with the rearages and CARES money and all that stuff. And it was very disruptive to their other commitments. So I wouldn't want to leave them.
Yeah, I think what we're saying is we also don't want to commit the board if we've only allowed for, the commissioner's joined us. Welcome, Commissioner.
Glad to be here.
And you are now confirmed.
Oh, how wonderful. Thank you so much. Thank you, Senator Pearson.
The narrow
Senator
boat,
Gis-
Commissioner.
Narrow, but most welcome.
Okay.
Madam Chair, I just wanted to make clear that everything we've done this past year has been so completely focused on the pandemic. So Senator Pearson, to your point, thank you very much for your confidence in us, but we are at the straining point at the department, and this work that you want done now needs to be done right. And I see it completely in preparation of this board launching. And I appreciate the weirdness of my conceivably hiring an administrative assistant and a lawyer for a board. But I think it's the best we can do if we're going to keep the momentum going here. And I'm happy to try to craft language that makes clear that this is a transitional thing.
That's what we're trying to do is give you, and I will trust if you say a lawyer is what you're going to need to get these grants out.
Part of that was the discussion in the House, and I don't know where you folks are, but there was discussion in the House of transferring a variety of fiber assets to the CUDs. That's in
I don't think we've gone there yet.
Right, and I don't know what the outcome of your conferencing is going to be, but if there's that type of transactional work in the offing, we're
okay. What we were talking about is giving you a budget, and telling you to hire or contract for, and maybe you can contract with an attorney to, if that's what you've got, because we're not sure the board is going to need a full-time.
I'm almost certain
attorney.
they will. I'm almost certain they will, because
They may.
there are so many unknowns that the board's going to have to work through with the executive director in doing this work. And you've got to have an attorney who has acquired the background of this stuff and is devoted strictly to their perspective. That's really the
All right. What we're trying to do is find a way to say, you've got a budget to hire whatever you need to get these 4 or 5 grants. They could be only 1 or 2 out the door in the time the House sees this board being up and running, like by October, given the level of expertise that we need. I'm not that optimistic that you can essentially hire one and appoint 3 more.
Well, that was my
Um,
testimony as well. That, I mean, I appreciate where they're coming from and the urgency is duly noted. But that said, and there was other testimony too to this effect. It's a very aggressive schedule. And
Yeah.
that's really part two to what I'm proposing is that long or short, at least there are resources I can work with
Right.
to keep the ball rolling until you can launch. I'm being very clear about asking for positions because I'm very nervous that I'm going to get caught in having money, but not, I can't
Yeah.
sole source on big dollars.
Yeah.
And it's just, at least on the administrative end of it, if you guys don't authorize a position, it becomes that much harder to actually get a position. And
Right.
get
No, we are,
something
we're committed to getting you and the board the personnel
I appreciate
that you need. I think it's trying, there is an awkwardness, and maybe because everybody's appointed by the governor, it becomes less awkward because there is a touch point. I mean, the executive director, the chair, and the commissioner are all under the authority of the governor. That there will be some cohesiveness, but the concern is that you hire somebody to work for you for 6 months and then the board, because we've only given them 5 staff positions, or is it 3? They only have like 1 they can hire on their own.
Let me just suggest to you this, since, as you've pointed out, these 3 touch points are all under the governor's direction. I have just as much an interest in the governor succeeding as the governor does, and you do. And so I think I can only underscore that I hired the best talent that I am able to find. Look at the Rob Fish position, for instance. Forgive me, Rob, for mentioning you by name, but that's a position that's going to transfer. I don't know whether Rob will go with the position or not. That's his personal decision. But assuming for a moment it did, this kind of thing's going to happen anyway. So I think it's an imperfect, situation, but you can have confidence that I'm doing the people's business for their benefit.
And since we're all meeting on Zoom, and nobody's sitting in an office being isolated, I mean, I can see personnel just kind of flowing, but, and we're all trying to go in the same direction. So Senator Hardy, you have a
Yes, thank you,
question,
Madam
or-
Chair. Well, so in looking at the language in the bill, I think one of the tensions is that on page 13, paragraph 7, we say that the board, in performing its duties, the board may use the legal and technical resources of the department.
Yes.
We say that in the draft, and that is a permanent thing, that they can use the legal and technical resources of the department. And I think that's what the commissioner is trying to address, is that if this is going to be a permanent ongoing arrangement, then she needs to have the positions to be able to have them use the services of the department. And then later, we provide staff for the executive director, including transferring one of the positions that's currently a public service department position over to the executive director. So there's an executive director, that position, plus we authorize 3 other full-time employees. So 5 employees total, and that would be 5 employees that are employed by the executive director and the board. But even after that, the board is still authorized to use the legal and technical services of the department. And so that's why I was saying we need to reconcile this. And it's fine with me if that's how we keep it. But the legal and technical services of the department are under the commissioner, and that is the department's services that the board is then using. So either we have to be saying that we're fine with that and those positions are under the commissioner because they're a part of the department, or we say these are temporary things and once it's up and going, then the board will have the legal and technical services of their own and no longer will rely on the department. And that's the tension that I was trying to identify that we need to address. It's a language issue and a position issue.
And I
And
think
to
we
your-
also say that they will use the administrative, at least it's been in there somewhere. So,
Yeah, Senator Hardy's really put her finger on it, Madam Chair, and especially when it comes to the legal resource, I highly recommend that you put that resource permanently under the executive director and the board so that they have confidence that they have separate counsel. But, and for the admin part, what I figured what you folks were trying to do was, give this entity the benefit of embedded resources at the department, and I can see the efficiency of that. But then I really need an admin position to be able to staff that function. So maybe, Senator Hardy, what we do is split the baby and have the admin function embedded in my department so that they can draw on those resources, because that's the reality of what they're going to need to do. But for the legal thing, I would recommend you specify that asset be with the board. And it's awkward if I'm hiring that person, but I can make clear that there's a 6-month review or whatever once the board takes over, and they can either confirm that hire or get somebody else. That's part of the reason for making it exempt.
okay, I think that's what I was hoping could happen, is that we could give you the resources with the understanding that once the board is up and running, that, yeah, you've got to like your own lawyer, and
Yeah.
there'll be a relationship there. I mean, they'd have probably a leg up in getting hired unless something had gone wrong. But that this be a temporary hire.
Yeah.
So,
So how many full-time permanent positions are we authorizing for the executive director / board? 5 or 7?
I think you may be authorizing 6.
Okay, 6.
So- Because the
So-
lawyer goes with them as soon as they exist, and the admin would stay with me, but is devoted to their work. I suppose you could trim them down to 4 and give me the admin, and that makes it a total of 5.
yeah, I think that works, because they don't, there's also the possibility of contracting and not hiring full-time. We just need to give them the staff. We need to give you the staffing you need to get whatever grant applications come in this year out the door. And that's probably going to happen very soon. They need to get out. And then we need, you're going to need to have somebody, and maybe that's the lawyer or admin, to do the pre-construction grants. And I think that's up to 9 million. So we need to make sure you have the personnel, and then as the board comes on, make sure they have the personnel. But at this point, until people actually get working, we may think we need a full-time lawyer, but it may turn out we don't need a full-time lawyer. We need 3 secretaries to do all the paperwork, and we don't know. So I think as general as we can make this, I would just soon give you permission to hire 2 part-time staff, whatever the temporary staff is, with the understanding that there's going to be a full-time position opening up, or leave the admin with you, hire the lawyer or contract with it, and then with the understanding there will be a full-time position in October, probably starting the first of the year. If we can do that, Is that acceptable to everybody? And we'll let the board have up to 5. Well, they can hire 4 staff if admin stays in the department. And if they need more staff, they can come back to us in January and tell us, we are up to our eyeballs and we can't get these things out. So you need to give us X, Y, and Z. Because we don't know.
I think I agree, Madam Chair. Flexibility makes sense to me.
Okay. So Maria, can you draft that? Does
think
it make
so.
sense to you?
I think
It's-
so. One of the things that, keep in line with what you just said, I think maybe striking that first sentence of subdivision 7, that the board may use the legal and technical resources of the department for the exact reasons that Senator Hardy pointed out, that that's a permanent ongoing thing.
Yep.
But what they will be doing is on an ongoing basis is providing administrative services, and they'll be able to hire a position for that purpose. But then in terms of the hiring language in general, just putting it in session law and then drafting something that's a little more transitional, and ensuring that if there is a legal position that's filled, that it will then be transferred to the board or something along those lines. Does that generally capture what you're thinking?
So, yeah, there's going to be 1 full-time in the department. That's staying there, then another full-time or 2 part-time, whatever is needed to get the grants out this year and the pre-construction grants. And then admin stays. The other position, which at this point we're assuming is going to be legal, will transfer. Yeah, I don't know how we word it. What we said is it's a part-time position right now. The board will hire 4 staff, and this legal is likely to be one of them. Or we can just transfer it and say, that's it.
Madam Chair, if I would just ask that you reconsider and that you make that a full-time position. There's just so much that this board.
Yeah, no,
cannot
for
just
the lawyer?
sort out. Yeah, exactly.
Yeah, that's up to you.
Oh, okay. All right.
And if you may, I want to say, if
Okay.
for some reason you decide it would work better to do part-time and, with 2 people half-time, but if you say you need a lawyer, I want to give you permission within reason to hire what you need to get the job done.
Okay.
How we word that, I'm not sure.
Okay.
Senator Pearson.
I guess I'm not clear why, Commissioner, we couldn't just give you money for legal services as opposed to why the position is important, because as you identified, it is awkward to have you hire the director's lawyer in a way. But there was a reason, but maybe I missed it.
Senator, I don't think there's a very deep reason here. I am leery of the contracting rules that I have to deal with in state government when it comes to trying to retain somebody via contract as opposed to hiring them into a position. So that's item 1. And when I think of the difference between a private sector legal hourly billable and what it costs to hire somebody into such a position, I think the state and the people will ultimately fare better by having an employee as an attorney as opposed to trying to do this on a billable hours basis. I have 2 outside legal contracts that I can think of, and it's just astronomical. The good news is that I get to bill it back. But what we're talking about here is funds that we would all rather see go toward building infrastructure and the like than paying $300 an hour. So that's the extent of my thinking, but I'll defer to your judgment, whatever you think is best.
So the easiest thing might be to just go with the commissioner's wording. The legal position would transfer to the
Yeah.
board. And this is an exempt position, right? So
Yeah.
if the board doesn't like this person, they can be gone. Is that
That was my thinking, but
okay?
that's about the best I can do. So-
I think that's maybe the best we can do. Okay, Senator Bray, did you have?
Nothing more to add. I was just going to say, I think full-time hire, especially when you're starting something up, someone who's on your team, who's sticking
Yep.
with you, whatever they learn carries forward, is so much better than someone coming in to just, take care of a task and then they leave. So
Okay, we've got to get back and get through this because we're a half hour off. Faith, do you think we could just cancel H88 for today?
Certainly, I'll do that.
Then we have to be done by 2, which gives us 23 minutes. So I guess we're not making any changes, so. All right, Maria, you've done some more drafting. No, that was there.
No, this was there, and
Yeah.
I may redraft that language just a little bit, as I said, put it in session law and just clarify. But then, so moving on, so we can at least get through some of the changes. I think you wanted to specify that the board is subject to the Open Meeting Law and the Public Records Act, with the understanding that there may be some proposed amendments forthcoming. Then with respect to the executive director, I think you wanted to specify that the executive director is appointed by the governor with the advice and consent of the Senate.
Yeah.
That is what's added there. So under the pre-construction grant program, I wasn't certain. There was some discussion yesterday about the House proposed $9 million for interim, the department allocating and dispersing funds until the board is up and running. I think there was a proposal to maybe increase that amount subject to JFC approval. So that's what I've included here. So the department is authorized to allocate and disperse up to $9 million or up to $14 million if an additional $5 million is approved by the Joint Fiscal Committee under this program on or before December 31st or until the board is operational, whichever occurs first.
I think that gives us all the escape hatches we need. I think 9 million is going to cover it, but if I just remember, I think it's the VEPSI loans have come into the e-board because they had 5 million more they could do with approval, and they were up against it. So I'm not hearing any screaming, so we'll keep going.
Okay, and so just to clarify, those are for pre-construction grants to go out.
Right.
And there is for your consideration a similar provision under the construction grants.
What did you just
I'll get
go
back
by
to
in
what I just
yellow?
scrolled
'Cause-
past. I'm gonna go back to that. But
Okay.
I just wanted, because this is similar, this is interim funding for the construction grants. Same model as what we just looked at. If you wanted to allocate some funding now to go out immediately, I didn't fill in the numbers. I wasn't sure exactly where the committee was on this.
I think this is less, but I don't know because we don't have an inventory unless Rob Fish does. Why don't we put the same numbers in there? it looks like the big construction grants, at least the one we got from CV Fiber, was like $5 million next year. But that's the Washington Electric build outs, or connecting up to them.
Well, Washington Electric is hoping to get loans
Right.
for fiber. What about if we just sort of think of this whole season's universe as 20 million between
Okay.
the two? And so I don't quite know how we
If
do
we
that.
put 9 there,
Senator Pearson, are you suggesting instead of having individual buckets for the pre-construction and construction, that we just have one and that they can divvy it up? I actually think that's a really good idea. Just having one of these paragraphs, Maria, that refers to both of the grant programs and say up to 20 million or 25 million with approval by JFC or something like that.
I think that there's logic there. My hesitation is that as we've all heard, we don't think major construction we're really ready for it. So somehow, if I could only pick one, which is sort of normally the posture that we're in, I would pick pre-construction. But where we pick these numbers, it should be more than arbitrary.
The commissioner has her hand up. Maybe she has some numbers.
I can't see the commissioner now.
Right.
Commissioner, do you have an idea?
In our shop, the number we had for construction was 10 million. And the way we were thinking of it was whatever does not get spent this year on that will revert to the board anyway for future use. And, this needs to be appropriated on the basis of plans and the like. So it's a controlled risk. I love the 20 million figure, frankly, because we don't know what we're doing. I know we've spent close to $2 million in the last year and a half, 2 years on planning. So I think the momentum is there for some good work to get done this year. And you don't want those folks to be hamstrung by our not having adequate resources. You have joint fiscal as the safeguard, and that worked pretty well last year with the CARES Act money. So
Yep.
I think you can have some confidence whether you give us the 9 million, the 10 million we were thinking of, or the 20 million that Senator Pearson was graciously volunteering. So,
20 million, and then as it
Yeah, that
changes,
was-
you can do that.
So
Senator Pearson.
so let's do 10 and 10 in pre-construction and construction, but then allow movement between if joint fiscal approves at a meeting. So the commissioner finds that actually had like 15 in pre-construction and only 5 here. We've only used 5 here. Does that make sense? So
I would just let them move it on their own,
okay.
because joint fiscal,
I'm trying to make it easy
we're
on
hoping
Maria.
not to meet weekly,
Yeah.
like last year.
Yeah, I
That's-
think
As
combined
things
20.
plays out, let the department move things around.
That's
They'll
fine.
have a better idea once we're out there.
yeah, a combined 20, and if they need to come in to joint fiscal, they can come in and ask for more.
Up to 5 million more. Does that work?
Yeah, I don't even think it matters because joint fiscal can say no. If they come in and ask for 50 million, you can say no.
Okay,
So
that can be sent with the approval of joint fiscal
Yeah.
committee. All right.
So did you want to say 5 million more or not? Or
I
leave
think
that
they like
open?
an
They can-
open door. So you want to do 5? I think 5. That
Five's
seems to
fine.
be the
Five's fine.
number that gets used a lot. Okay.
So 20 million can be divvied up as Commissioner deems appropriate, up to an additional 5 million more with JFC approval. And I'll just put that in session law.
Yep.
I think that might be easier. Okay. Oh, so now let's go back to the yellow highlighting. This is for your consideration. I put this in yellow because this is not something you discussed previously.
So Maria,
It's something Senator Pearson, Yes.
Madam Chair, could I tee this up? Because this was my request.
Yep.
We've heard the plenty of nerves from the CUDs over the last few days because we've been trying to not shut out the small telecoms. But as we know, if a small telecom was in smack dab in the middle of a CUD territory, we might be weakening the CUDs while we're trying to also have flexibility. So how to handle the Franklin Telecom while you protect the Kingdom fiber, I don't know. This was an attempt to just acknowledge this. I don't think it's a big change, but if Maria would put the language back, it mandates that the board think about the CUD. So before the board awards a grant to a small communication carrier, or I would say awards a grant to anyone other than a communication union district.
Yeah.
The board shall make a reasonable effort to determine that grant does not conflict with or undermine the deployment plans of an existing CUD. It's something that says, because the risk is that the cherry picking, as Sarah McDonald says, we can't fall for this again. And basically we've decided the CUDs are our protection and we can't undermine them as we go. But I think we've all discussed, we'd like some flexibility at some level. I'm not that concerned about who builds broadband. I want broadband built. So this was my attempt. I don't know what people think.
Yeah.
It is trying to answer what concern from the CUD.
Oh, it says we're now streaming live on YouTube. I didn't realize we hadn't. Okay. That's similar to what we did last year with the CARES money. We started out with a veto and this just said, you got to look at it. If they're sitting right down in the middle and dividing up this, you can't do that. On the other hand, if 3 years from now, the CUD is still not formed and not ready to do anything, you may reach a different decision, but okay. That
I guess
okay
I
with
could-
everyone?
Yeah, I have a question for Senator.
Yeah.
Pearson.
So
Send a break.
So does this replace, yesterday there was a 3-county construct. Is that,
No,
that's
that's
gone?
that's in the definition of a small carrier, I think, earlier in the definitions.
All right. Thank you.
Okay, we got to keep moving.
let me just ask a question here, though, of whether or not the extent to which this provision could conceivably hamstring a small communications carrier that is outside of the territory of a CUD. If
Why?
the CUD, for example, and I take Franklin Telephone as a classic example. Although there is a CUD in other surrounding towns, there is no CUD that covers the town of Franklin. If the CUD said that they are planning to extend into that location, even though it's not within the territory of their existing CUD, could they get hamstrung by a provision such as this, that their service plan may conflict with a deployment plan of an existing CUD?
I will say very clearly, it's not the intention.
Yeah.
And I think you have to believe that the board is going to have enough of an understanding of the basic economics of what we're talking about. What the concern is that you take the more profitable areas out of a CUD district for some telco, and then the CUD business model goes belly up. So what the example you've given is a future proposal from a CUD. I don't think so. I mean, everybody has the opportunity of working with a CUD, but you know, look, I'm not saying this is the answer. I think this is a real concern. It's a legitimate concern. This is my attempt to land on it. And Maria, if you will just change that lead in there so that it's a grant other than to a CUD. I think it gets there, or at least acknowledges it. You know, I mean, I don't see how the board would say to Franklin Telecom, well, maybe one day there will be a CUD here, and so we're not going to give you this grant. That's not what the words say.
But
No,
yeah, you,
And I understand that. What I'm saying is if the CUD that covers that area decides that it does want to extend, and that is part of its plan.
Well,
it
If
has to
that's
have
our
a
deployment
town
plan
vote
is-
to come in.
Yeah,
They can't just
exactly.
annex land.
Yeah. The town of
Town-
Franklin would have to vote to go into the CUD. It's not like the CUD is, you know, going to have a, you know, hostile takeover of Franklin. That's not how it works. These are municipal entities.
Well,
And
I
we
guess
could-
that may be an underlying question that I don't have a full understanding of, is does a CUD have to have the approval of a town before any of its lines can go into that town? If
Yeah.
it's a
Have to
non-member,
join,
is
Yeah.
there something?
have to join.
It's like a water district, Senator
Yeah.
Brock. I mean, you can't just be foisted up some plumbing.
Want to run
I think so.
the wire,
So what-
water lines through Berlin, you got to get permission of the town of Berlin to run your water lines through.
What
I mean,
about if
seen
Sarah
the
Brock?
document Says that, and I take your word that that is the case.
Okay, we're gonna need to move on because this is one of those things that we're trying,
So we're comfortable with that?
I think so.
Thank you.
Okay, let's keep moving.
Okay, so then this is under the centralized resources for CUDs. I think you wanted to add a provision that says that they can assist CUDs with obtaining access to fiber networks owned by the state or by an electric transmission or distribution utility. There's another provision that addresses this in the reporting requirement, which we'll get to, whether there are recommendations that would increase access to this state or utility owned fiber.
We all got the email today about Velco and high tension wires, and if you didn't get that one,
No,
I'll
we
get
did.
it out to you.
No, we did, and it doesn't undermine the point. Nobody's saying you
Yeah.
have to use Velco. We're just saying we need
Look
to
at it.
We're saying they're a middle mile fiber, and shame on us if we don't try to use it when it makes sense.
All right, keep going. We added
And
natural
yep, natural
resources and
resources is
energy.
going to receive the
Yeah.
annual report. And then this language here is the report back, recommendations concerning increased access to and use of fiber in furtherance of the goals of this chapter. And then under the organizational section, I think you were talking about putting that time limit on the appointment of the executive director position.
Oh, within
So I
60
added it
days
to
on
within
this,
60
the
days.
commissioner-
This is
Oh,
the
offer,
governor
all
will
right,
have,
space, all right.
yep. So we're getting into some sections that you haven't looked at before. This section 4 concerns the existing broadband innovation grant program. There's about $60,000, or at least there was $60,000 left in this program. So the proposal here is to repeal this, but you'll see in the effective date, the repeal is not effective until January. So this will be program, they'll distribute whatever money is remaining, and then eventually it will be sunset or repealed.
Okay.
This section 4A is proposed to be stricken. This is the existing rural broadband technical assistance specialist, which you've already specified would be under the oversight and management of the executive director of the board. So no need to restate that here. Then a question here. So under the House proposal, we're now talking about the universal service charge, and specifically the 0.4% increase. And what the House did was transferred all of that money, all of that revenue to the new authority to pay for their operational costs.
Yeah. My
You
preference.
Yep, you have the operational costs coming right out of the fund. So the question is, if you want to keep that, going back to the 4.4% revenue, do you want to leave it in the connectivity fund? And if so, do you want to specify that it's to be used specifically for the connectivity initiative? And the reason why I propose that is because that's what this money is used for under existing statute specifically. What's stricken is the taking out to fund the rural specialist position. So, right, so you can see up
We're
here where I
paying
have
the
the
rural
cursor.
specialist out of grant funds.
You'd be paying, under your proposal, you have that coming out of grant funds. So then the question is, the remaining amounts, do you want to specify, as you do under consistent law, that that money goes to the connectivity initiative?
Okay, I think if we want to retain this is an ongoing source of funding for someone's salary. The grant funds are for only 2 years. This may be maybe he won't want to transfer. We haven't had time to even look at the connectivity fund, but I can see where if we left the broadband specialist in the connectivity fund for now, it might ensure continuity because it's a more secure source of funding for your job than a grant, which is only going to last 2 to 3 years, and just leave the rest of it alone, because we're going to have to do some looking at the connectivity fund in the next couple of years.
Okay, so have the specialist, this funding source continue for that position, is kind of revert to existing law.
But
Yeah.
Are we deciding to raise the universal service fee?
No, we're doing this now.
No, this is right. So under existing law, that incremental increase in the rate, the 0.4%, goes to pay for the rural specialist, and the remaining amounts go to the connectivity initiative. So you can just, it sounds like the chair's proposal is to keep that structure in place.
Yeah, I think that may be the source of maybe he won't transfer. You can transfer the position, but that's a more secure source of funding, and it will free up some grant money to do other things like string fiber. Not a lot, but okay.
Okay.
All right.
But would we continue with the connectivity initiative, which seems to be redundant or unnecessary with this other stuff going on?
Not doing anything with it this year. If we let it ride, the board can come back and talk to us. We also need to talk, because this is all the universal service charge. This is where we've got the issues with E911. They're funding that for 2 years with grant money or ARPA money. We need to be able to come back. We need to be able to work on that next year with focus. And I'd just soon let it ride for this year and not make any changes until we have a chance to come back.
Right, I understand about the fund, but there's this whole initiative with actual stuff going on.
It actually hasn't been very much money, and the commissioner said one of these emails, she wasn't planning on doing anything or taking any more RFPs for the funding.
She has her hand up.
I can't see her. Commissioner, you just have to holler in this committee.
Well, I'm trying to holler strategically.
Oh.
So What I would suggest is this, the connectivity initiative is what the state of Vermont has had all these years since the VTA to do anything at all on broadband. You now have significant federal funding to do a very important thing, connect the unconnected. And that's where your focus needs to be right now. The problem with the connectivity initiatives, you've got a whole bunch of statutory criteria that go to continuing what we've been doing so far. And there's been a lot of back and forth about whether you want 25.3 or 100 up, 100 down, et cetera. If you want to bring the focus of the state on what we're doing with this federal money right now, I would suggest you leave the connectivity initiative dormant. And that's frankly one of the reasons why I've just not done anything with it this year, because I didn't want to get in the way or at cross purposes with whatever it is we're going to be doing if this legislation passes for the CEDs. And as you pointed out, Madam Chair, there are these revenue issues that also need to be addressed. But I would highly recommend that you keep the funding for the rural technical specialist intact, because while I don't have regulatory jurisdiction over broadband, that position has been the eyes and ears of the department on broadband so far. And right now we're going to have a different entity. If this legislation passes, it's going to be dealing with broadband, but there will come a day where you may want the department to have eyes and ears again. And that would be the easiest way to secure it, frankly.
Okay. So is there a way to just declare it dormant,
Yeah, I was going to ask Maria, is there a way to do that in statute?
held in abeyance?
There is. I can add some session law. I'll come back with some language, but yes, you can specify that. But that also, if we can just look back at the draft for 1 second. So the House did not specify that it was dormant. So it was intended to be an ongoing program. The question is, do you want to accept the proposed amendments to that program? So in some sense, it aligns more closely with the ARPA funded construction grant program. For example, the speeds, minimum speeds were increased to 100, 100.
We're
Right,
now,
so do you,
what I would prefer at this stage of the game, and we are now cutting into the next thing, is we strike it. That means we are going to discuss it in conference. And if we decide we want to do something, but this is highly technical and we are not going to get that done today. I mean, just changing speeds, and I think we've got enough money to get out the door. And remember, all those legacy carriers and stuff are eligible for the connectivity fund. So I think,
Is there
We
any money in
just-
that fund?
is there what?
Any money in that fund?
Yes.
Yeah, it comes off the universal service charge.
If memory serves, the balance right now is about $1 million. And that was one of the reasons why folks were looking to it to deal with the E911 problem. So for what it's worth.
Well,
So
it's
when-
striking it right now. Will that potentially cause an inability to extend service to people who would otherwise qualify under the provisions of its use in the past? Would we leave people unconnected by striking this and not leaving it in place?
Yeah, I can't speak to whether you'd leave people unconnected, Senator Brock, but you are identifying the point that for if the Franklin telephones don't make it into one of these two bills, the connectivity initiative is the way a Franklin telephone might otherwise get funding. So those projects will come to a halt. That's correct.
But would it
I'm-
also affect projects that might involve individuals who would be connecting to Comcast or others and leave them to dry?
Yeah, it would certainly putting the connectivity initiative on ice would mean that a Comcast would not have an avenue by which to seek funding for extensions of its system. The connectivity initiative has not serviced individuals, if I'm understanding your question.
I understand what you're saying, and I agree with it, but there are places that serve people that would not be served if we drop the connectivity initiative. And I wonder if we can simply leave it in place and resolve and fix it in the conference committee.
Okay, I was going to take it out, which is because we're not concurring, which then means we're going to have to discuss it. And we have not had time to discuss it. And so I think it should come out. That means it's a topic for discussion in conference, and that will give us time to take some extra testimony as a committee and get a position, because
Madam Chair, another thing you might consider is that the House has dealt with this issue by moving the connectivity initiative into whatever entity is created. And there, at least you have unity of command, because there you have the new entity exercising the powers of the connectivity initiative, if that's a preferable way to go.
and see, this is something we just don't have time to get into at the moment. That may well be what we decide we want to do.
Well, this is
But-
why I haven't done anything with it, in
Yeah.
order to preserve your options. So,
We're going to have to do that in conference, because we are now 7 minutes into our second set of testimony. And we're going to come back to this at the end of the day. I've got to give Maria something to draft.
Are we gonna
So-
at least go through the full bill now?
That's what I'm trying to
Okay.
get through. All right, so Maria, keep going.
Okay, so it
Senator
sounds like,
Pearson.
Yeah, you're gonna be mad at me, but Maria, in that language, the yellow language that was now E about protecting the CUDs, I think that's where you struck what we used to have there, which was about overbuilds. And I don't know why, I certainly wasn't.
We wanted
interested.
the overbuild in there.
Yeah, and I wouldn't,
I didn't strike anything. I'm
Well,
not sure what the question is.
well, all right. In the last draft,
Uh,
we had language here, yeah, that
Oh, building through another,
yeah,
It's now on
District.
F. It's been
now-
relettered as
Oh.
F.
Okay, thank you. So I just was missing that. Thank you.
okay,
No,
All right.
no, sorry. Yep.
all right, we'll keep going. So the whole thing
So
on
the
broad,
connectivity initiative 7 and 8 for this finance amendment, they'll be taken out. Is that right?
the connectivity initiative.
Yep, the connectivity initiative positions. So just one other thing.
Oh, yeah,
Yep. So, well, not one other thing, but we kind of jumped ahead a little bit. The transfer of fiber optic assets. These are existing assets that the department manages, the state property. The proposal here is to transfer them to CUDs where those assets are located.
Yeah.
Yeah, basically if they want them.
we,
Do you have a position on that or?
I mean, we don't know anything about it.
Well, I think it makes sense. It's like saying the municipality gets it. We've already said that if the municipality goes belly up, it comes back to the state. So if we don't do this, then I would say they have unfettered access to it or something, but I think this is fine myself.
All right. I mean, this is another one I just soon strike and then deal with in conference, because we haven't taken any testimony. I don't even know where the assets are or what they are. But,
This is just saying when they're in a CUD territory, the
Yeah.
CUD can have them.
all right,
I'm fine with it too.
okay, keep going.
Okay. So the next section we're gonna get to concerns the Telecommunications and Connectivity Advisory Board. Did you want to keep this in? The amendments here were just reviewing its responsibilities with respect to reviewing grants under the Connectivity Initiative. The House proposed to take away that charge because the department no longer is giving out the grants. But otherwise left that body in place. It's an advisory body. Do you have a
I don't care.
preference on?
No, all right, keep going.
Or leaving that, I'm sorry, was that a,
No one objects to leaving it in.
okay, so that will stay in. So then that brings us to the broadband expansion loan program. This is the VITA loan program. We haven't really gone through this. We walked through this, but there are some amendments to the existing loan program. Basically specifying that the goals are to achieve universal broadband coverage in a community or a CUD. Among other things, it makes the program a revolving loan program. And then also with respect to the eligible borrowers, you can see what I have up on the screen there. It was used to be open to almost any entity. Under the House proposal, eligible borrowers include CUDs and ISPs working in conjunction with a CUD or a municipality. Just giving you kind of a quick overview of, what some of the changes were there. If you do want to keep this language, I just have to, make sure the references to the Vermont Community Broadband Board and not the authority. The amount of money, the funding that's available has stayed the same. So would you like to talk about these provisions some more, leave it in the amendment, or strike?
Much for have we got to go?
We are very close now.
Okay, let's go through and we
okay.
can think about these and go back and
Okay.
read them
Okay.
at the end of the day.
I
'Cause
think you've
they're gonna
already
be
decided section 12. Yep.
All right.
I think you've decided the clarification of the trade secrets for CUDs. I think you've already decided the property tax exemption to strike subdivision 20,
Yeah.
which
and let
concerns
them-
the ISP. So that's the only change that I've made in the property tax, just some conforming sections. And
Wait,
that brings, yeah.
What does that do?
So I think yesterday you were discussing under the property tax exemption, there are two eligible property owners for this exemption. In 19 are the distribution utilities. And then in 20 the proposal was for any internet service provider. And based on your discussion yesterday, you wanted to limit the availability of this exemption to just the distribution utilities.
And I think part of the reason we struck that is because we're having trouble understanding what they were trying to achieve, and the tax department said it wasn't clear and would be. So this is another one that we can talk about in conference if they want to expand it. But
we think this handles the Washington Electric request.
First one should handle the
Yes.
Washington Electric request.
right.
Yep. Okay, and then we just get to the communications workforce provisions. So that's the needs survey. That is the incumbent training program and the apprenticeship program.
Okay.
So
These all seemed really kind of not very well thought out and a little lame.
That's where we are. But this is just a small corner of a much bigger workforce development initiative that's in the budget.
Right. There's a bunch of stuff in the budget. This
Yep.
seems unnecessary, and we do have the language about authorizing the board to spend money on workforce issues if they identify that.
This is just asking them to, I think, establish or set up the framework for an first survey and find out what the need is, which is probably a good thing. And then to set up I gather the framework of an apprenticeship program. Is that what's going on, Maria?
well, yes, for the apprenticeship program, And I think the amount of money for that was somewhere in the neighborhood of $90,000 to set that up. And then the incumbent training program, there was not an appropriation for this. This is something that's, it's already been started. So this would be additional funding. And that what you can see there on line 21, up to $40,000 is appropriated. So this is just authority to take money out of the existing training fund that the department has for this particular program. So there's not an appropriation for that. So
Okay.
do you want to keep those in or strike them, or not sure yet, or?
I don't care.
I mean, they seem both benign, like it wouldn't matter if we kept them in, but it also doesn't seem very they're not very solid, it seems like. So I'm not sure if they're that effective. But I mean, I could go either way. It feels like a sort of a little, like I said, a little lame.
Yeah, it is not. I think they ran exactly where we run. Is you get to the end and you want to put a placeholder in there, but you don't have time to flesh it out. This is the end of the session.
I mean,
Okay, does anyone want to take this out? Okay, I haven't heard anyone say take it out, so let's move along.
Okay. And so then the appropriation, just striking essentially what they had. You've covered everything in terms of transferring the administration of the NBRC grant. But so the big issue is the amount. And I believe you're working with 100 million. It's all going to the fund. And then you specify some of how that money goes out, or at least what the allowable expenditures are under that statute. So that would be your appropriation section, section 21.
Section we did most of the work on.
All right. And section 21 is just a statement of legislative priorities. If there are additional federal funds available to the state, that they support the new board and the new fund, basically. And the effective dates, property tax. I think we talked about the innovation grant programs, and connectivity initiatives not relevant because you're striking that section, and the advisory board, the changes there would take place in January.
We do have in here our requirements and priorities that a grant would be judged by or measured by.
Yes, you have all of those are under
That's
your.
what I thought. I
your
just
grant
want to
program.
double check.
Yep.
Okay. So can we send Maria out to draft? Senator Bray?
Just a quick question, Maria, does this draft include the ability to access polls on private rights of way?
I have a standalone what I sent you earlier. Just wasn't sure of the procedure here. Would you like me to pull that up so the committee can look at that language?
If the committee would, I think it's worth.
What is the background?
So this is something that Holly brought to us before, and Irv Tomei both. It says that basically when there are some landowners that have questioned whether or not broadband providers such as EC Fiber has the right to access poles on which they've leased space from the pole owners to whom the landowner has granted an easement. Like
my backyard where all the electric poles run through. All the poles in our street are in the backyards.
Okay, well, so maybe that's a good example, but there have been issues that came up where a landowner said, oh, I agreed for the telco to go through, but not you on the telco.
Okay.
So it's it's an area of vagueness, and if we could specify it, then it would just it would preclude people getting tripped up in this way as they build out. And so we heard about it, I don't know, 6 weeks ago, and then I got a reminder again lately.
Okay. Marie, you've got that?
Yes, so that's what's on your screen now. This is the proposal. So it states utility easements and state rules regarding utility rights of way and pole attachments shall include as an authorized utility use the installation of fiber for purposes of providing broadband service to the public. Such use of the utility easement and right of way serves the public good and facilitates the construction of broadband consistent with this act. Contemplate.
So
Problem with that? Okay. Committee? I'm going to send Maria off unless
It's just a
someone's.
Madam Chair,
Yes.
it's just a question for Maria. I thought we had included some language that discouraged overbuilding in areas that are already served, and I just missed that. Did we in fact include that?
Yep, the overbuild section.
Yeah, where
Yes.
is that in?
Yep, so it's in section 2.
Okay.
Let me go back to that document.
So, Madam Chair, I couldn't quite hear your mic cut in and out, or my
Oh.
end did. Were we fine on the pole easement stuff?
Yes, I haven't heard any objection.
So the overbuild language.
Yep.
That's in subsection F. It was E. It's now relettered as F.
And that's page what, Maria?
And that's page 19.
Page 19.
Right under the yellow highlighted.
Okay.
Right. So I didn't strike any of that language we reviewed yesterday. I did when I added the new provision that's highlighted in yellow. I just relettered those existing provisions.
Senator Brock,
Yeah, thank you.
I continue to not totally understand what we're trying to do here.
Yeah.
Because we want the CUDs have to pick up some people downtown in order to have a business model that helps them serve the end of the dirt road, right? So, Sarah McDonald, I'd be interested what you think, because you've forever talked about the importance of the cherry picking. Does this worry you?
Worries me, but you gotta go to where the locations that are unserved, and I don't know where, and you're going to get a subsidy to help you in recognition of the fact that you can't get there economically without the grant. You shouldn't get the grant and then grabbing a couple more tomatoes as you're going through the market. So
I think what this says is you can't just go and do downtown Newberry because it's nice and flat and also served by Comcast or Consolidated, because you can pick up a lot of people. You have to go through it because it's the most
That's how you get there.
economical way to get out to East Rygate, which isn't served. And I have no idea who serves what. But if we say you can't pick up any new customers downtown, we're really stopping competition.
Yeah. The issue was partially raised, I think, by Duncan Cable, given their situation.
Duncan Cable was the reverse. It was they had a higher level of service, and
yeah,
the competition was coming in with a lower level of service for less price.
Well, again,
Concern was they would.
Yeah.
Okay.
Okay.
Committee.
If if you're going down the road.
I'm trying to
someone should
get
be
you a
able to
whole
look up to you.
5-minute break so you can stand up. If your back is as tired as mine, we've pushed the next meeting off to 2:30. We have 5 minutes. Senator Hardy, is it?
I just wanted to say, we just got an email from Christine Hallquist saying that they would have a $5 million build project this summer. So,
Okay,
the 20 million is at least that amount is necessary to make sure we get all the build projects that we can as
Okay.
soon as possible.
okay. 5 minutes, folks. Be back right on time. Just stand up and
Good.
do
Senator
some
Cummings,
calisthenics.
can I just want to clarify, did you want to leave in the Vita loans provision or just take them out in the strike all and deal with them in conference?
I didn't hear anyone say they wanted to take them out, so.
So just leave them in. Okay,
Yeah.
got it.
Madam Chair, do you want me to stick around or shall I get off and you let me?
No,
back
we're
in?
going to be doing property
All right.
taxes, something, I think, at the
I
end
will-
of the
okay.
day.
I'll leave, but Faith can get me with a simple email, okay?
We'll find you if we need you, but I
Yeah,
think
glad
you're
to help
okay.
you. Okay.
Okay, good.
Senator
Thank
Cummings,
you.
I'm
Yes.
not gonna take you off live because I'm afraid it will take us forever again.
You get back,
So,
that's right.
I
So
will mute
everybody shut
people.
off your video
Senator Cummings, I'm going to let Steve and Mark Peralt know that we'll probably start at 3:15 or 3:30.
Oh, are they the next group up? Yep.
Yeah, they're the next group up.
Okay, my printer cartridge arrived.
Oh my God, Christmas time.
Christmas time, I'm
Just in
back in
time to
business
decorate.
if it works. This is one of those refilled. Okay, my printer cartridge.
Senator Cummings, you've hit your 2:30 and gone beyond. If,
Okay, then everybody needs to be back here.
And you are live still.
We are live. All right. Find my agenda, we're back to work. Okay, we are back at work. I think we are on to miscellaneous energy subjects. This is, I believe that's what we have left. We canceled H88. Yes, there's Ellen, so it must be energy. So Ellen, we had a couple, we went through this some time ago. Can you just refresh our memories about what is in this bill?
Sure.
We have it.
Yep.
Okay.
So it's been about a month, I think.
Yeah, that's a long time. We're only thinking about broadband right now.
Yeah. So H431 is miscellaneous energy. The first section is a small change clarifying the different jurisdiction between OSHA and DPS when there's an accident. The second section is adding, again, some clarifying language around cybersecurity issues being exempt, cybersecurity information being exempt from the Public Records Act if DPS comes into possession of it. The last section of the bill is about the NDCAP program, the Nuclear Decommissioning Citizens Advisory Panel, and having North Star provide some of the funding for that panel. But then the third section, the one in the middle, is the largest, and it is around the regulation of energy storage facilities and how they're regulated by the PUC. And so your committee has also—
This is a bill that we had that we are attaching, plus an addition from Senator Pearson.
Right.
Okay.
So you have some witnesses today, I think, related to S128, which is another energy related bill that related to the energy tax issue. And it's related because 431 does have a few sections related to energy storage, and S128 also does. So,
Okay.
but I don't have a lot to present to you today, other than maybe you can come back to me at the end. I wanted to remind you that you've received a few different proposals for amendments. And
I know we have the one to add hydrogen as a potential storage problem, and I haven't heard any issue with that.
Right. And almost a month ago, the Department of Public Service did provide a couple of other small changes they're recommending.
Just
So
that they wanted, and Greg Faber is here, I believe, on that one. So,
Yep, I'm here,
any
Madam
more
Chair.
refresh your memory questions at this point? Okay, I'm not hearing any. So we have Andrea Cohen. Andrea.
Good afternoon, with Vermont, excuse me, Andrea Cohen with Vermont Electric Cooperative. Thanks for squeezing this in on a busy day. I will cut right to it because I know you are behind and working on broadband. This probably feels like a nice break from broadband for a few minutes. We support 431. We are here requesting some additional language that would help in our efforts to deploy more community scale energy storage. And without diving too deep into energy storage today, I'll just share it's an emerging and very important technology. We're working really hard to deploy more storage. One reason we are interested in supporting this language that I believe you may have seen. I have a draft 1.3 from that Senator Pearson, I think, had asked for, dated 4/19, that speaks to the issue of the tax clarity regarding community scale energy storage and other storage. It fits nicely with the bill before you because regulatory certainty and financial certainty is really going to help us move ahead with deploying more energy storage, which we will see financial benefits to all of our members, and we will be able to manage the grid more efficiently with the more projects that we're able to put out. So it's good for the environment, it's good for the pocketbook, it's kind of good all around. What's causing us a little trouble is the lack of clarity on some of the financial parts of this, and the regulatory clarity that the department has in the bill will be helpful too. Let me just share, if I'm allowed to share my screen, great. I just want to show you a few pictures of, just to give you a little context of what we're talking about when we talk about energy storage. I just have a few slides. This is our Heinsberg facility. This is a 2 megawatt, 4 megawatt hour battery. We had some local partners. WEG out of Barrie was one of our partners. It's operational. It's been in place since 2019, and already it's saving us some money, which is fantastic. The way we're utilizing this, we set this up is, it is a kind of the equivalent of a purchase power agreement, but it's with battery storage. So it's called a BESS. It's a battery energy storage system. And the arrangement we have with the developers, we pay them to operate it and get some great efficiencies by using the battery. And then there's some financial agreements. And one of those things is that we pay the taxes on it. So it would be one, this is a great example. We have another project that we put out to bid. RFP is out for another community scale project in South Hero. And as we're doing our feasibility analysis, and we're just trying to see whether, it's a go, no go kind of situation when we don't have certainty about the taxes, that helps. That just kind of makes it difficult for us at times to make these decisions or make good decisions on behalf of our co-op members. So the language, I'll just show you a few more pictures. Let me see, I'm going backwards. It's going backwards, okay. So that's the battery. That was on Crane Day. That was the day it was being delivered. Let me find from beginning. That was Crane Day. That is what it looks like. It's basically looks like a roll-off container. You wouldn't know that what's in there. That was our opening day, the Veridity, our partner, our financing partner, and then the representative from WEG and our CEO, Rebecca Town, at the ribbon cutting. That's what it looks like when it's landscaped, all done. It's at our substation in Heinsberg, this battery, and the next one will be on our property in South Hero. So the language that you had, I'll just, if you've seen it or not, the short story is, it sets the, I'll stop sharing my screen because you don't need to look at that.
No, share your screen. I think that
Oh,
would
you
be
want to see
helpful for
that?
us to
Okay.
see. Yeah.
Okay.
I was just
Um,
getting rid of all of your pictures so I could read the whole
Yeah.
thing.
Well, this is just a little tweak to the language that is 4 pages of language. So I don't know if anybody has that handy. I can maybe pull that up myself. But what the language, those 4 pages do is it just some definitions. But the short story is it clarifies the UCT for community scale energy storage, because right now that's not clear. It defines it as 600 kWh and greater would pay a UCT of 50 cents per kWh. And the smaller ones, like the Tesla batteries, things like that, that are just kind of home use or small commercial use, those would be exempt from the UCT. Just to clarify that, because we don't really know the situation. The property tax for the same threshold above or below 600 kWh, what's in the draft bill we support, would be 25 cents per kWh for the property tax. So put those together, that's 75 cents. That could help. Something like this would help us get some certainty. The only change that we were recommending was how it's assessed is not on the energy output, but rather on the energy rating. The difference is the energy rating is static. It's predictable. You will know what it is. The energy rating, it's kind of like solar panels. It might have the ability to produce this much energy, but if the sun's not shining, it doesn't. So it's a very variable thing. So this would be a fixed rate versus like a variable uncertain rate. We think that's probably a better way to go. So we offered some language. I could potentially look at my desktop and see if I could find the draft that this is commenting on. But I just wanted to share, the main purpose is clarity, helps us do some planning. It helps us also, frankly, to avoid litigation and conflicts and appeals. It's just, we think it benefits everybody if we have some clarity on this, and will help us kind of tackle the technological challenges and opportunities in terms of more efficient grid management that we're really excited to get into. So I think it complements the bill before you nicely, because that gives the regulatory clarity. This would help give some of the financial clarity, and together it would really just set us on a good path for moving forward with deploying more energy storage. So
Okay,
that's
Senator
my.
Ray has a question.
Hello, Ms. Cohen. Good to see you
Hi.
again. So if this were a substation, how would you be taxed on a substation?
The substations are currently assessed. I don't know how they are assessed. Frankly, I think there's frankly some lack of clarity in that space as well. I think there's potential for clarity for all of our assets, but we're just taking a small part to
Sure.
you today.
Well, I mean, this seems to have a foot in both worlds, right? We've talked about it being associated with renewable generation as a way to, Senator McDonald's been saying, and others, make the sun shine at night. But it's also, because of it being a grid asset, it's a bit like your substation. So I'm just looking at, what else is out there that we compare it to. If you looked at nameplate capacity on a solar array, do you know what the rate is for taxing that? I know it's.
Yeah, this piggybacks somewhat on the method for how solar is assessed. It kind of mimics that structure.
Right.
in the bill. And I
That's
did
our,
find the
yes,
bill. If you want me to pull up the bill, I can.
sure. So
Alright.
this, when it was presented to us, does mimic the solar structure.
Right.
And I thought the property tax structure for the land under the solar array, Senator Pearson, is that what you had envisioned?
The language that Andrea showed us does come out of the bill and it's been tweaked slightly. I think Faith has the latest language, should be posted. So if we want to really see it, we could ask her to share it. But the premise is to mirror solar with one little step, which is it's been confusing about solar and the municipal tax, and we're trying to avoid that confusion. And that's where you see the 25 cents for the municipalities. There is some formula that Jill or somebody could tell us that municipalities use to calculate their own property tax for solar arrays. That formula is too confusing to replicate for storage. So we're just saying it's a 25 cent per kilowatt hour.
Okay, that has changed since the original.
So if I may, I'd say, I don't know what the right number is, but bringing regulatory clarity and certainty to it, certainly when money is going to have to be put on the line to build this stuff, the more uncertainty, the higher the cost of the money. So
this is the UCT language, and this number 2, and the other witnesses, I'm sure will do a better job, but I'll just give you the overview and back out. This is where it clarifies the 50 cents for the storage, the large storage, the larger than 600 kWh would be 50 cents. And then down here, it mimics the UCT that says if it's less than 600, it's exempt from the UTC. So that's the state UTC language that's in here. And then when you get to the property tax section, what it's trying to do, it clarifies that, what page am I on? At the top of page 3, the underlying land, this does not affect the underlying land, because I know the league had some concerns about that, and that's how this was drafted, to say that doesn't alter anything about the underlying land. And then you get to the property tax part, and this is where you get into specifying this look different. Oh, it's the next page. Sorry. Here we go. We're almost there. The top of page 4. So this is the small storage is exempt. And then the over 600 kWh would be 25 cents. And this is the municipal, the property tax section. So it's, in a sense, just clarifying, what taxes apply depending on the size of the storage. It does speak also to the co-location. If it's part of a solar project, then it's different, and it is, I believe, not taxed in this bill if it's part of a co-located with a storage. Our projects are, with solar, our projects actually are standalone, because we went where we had property and we owned it, and we're still maximizing grid benefits, and we're still actually, it's facilitating more distributed generation if we're able to manage load. So it still has that benefit of supporting distributed generation. It just doesn't, it's not co-located. So that's pretty much what I wanted to share. I could answer questions. I could come back with our storage experts if you want to dive into storage. I know you don't have a lot of time, so I just wanted to make sure you understood that we did support the language with that minor change that we had supplied about just talking about the rating of the storage facility versus the output, because the output is so variable.
Okay, so that's essentially what you want us to change, is that from output to rating.
Right, and there's
And
just
that
two
would
or
that
three
would work
places.
for you without other changes?
Correct, and we could
Okay.
supply that language, very simple language change.
I believe that's in the latest draft.
Oh, great, thank you. Okay.
Okay. So many people. I've got Senator Hardy, McDonald, and Bray in a straight line, at least on my screen.
Same on my screen, Madam Chair.
Ah,
Just a clarifying question for Andrea or perhaps for Senator Pearson. My impression, Chris, when you, and I could be confusing this with something else we've done, entirely possible at this point, but I thought you said that you were trying to set up the same sort of tax structure for storage as for solar projects. Is that right? Okay.
Yes.
And so Andrea, you just said that if this were part of a solar project, it would not be taxed. But if, since they're standalone, it would be. Is that, how is that possible?
Solar, I believe, would still be taxed.
But the storage would not be?
That's my simple reading, but I'm not a lawyer, so it's worth just looking at that.
So wouldn't we want them both taxed at the same amount if they're part of the same project? Or
That's on the top of page 2 for me. There is assessed the tax for the storage facility, and that is not connected to a renewable energy plant. So that's just worth making sure it's clear.
So you're not storing 24/7 power. You're storing solar, right?
I
In
guess
this example, there's assessed on any station.
I guess it's, I'm just trying to figure out what we want to do. If the intent is to have it assessed and taxed at the same way, if whether it's storage or solar, then we would want to make sure that that's true, whether it's with a solar array or not.
okay, I think that's, when we talked about this originally, it was a storage facility attached to a solar array. Andrea, did I hear you say you're standalone, you're not with a solar, so you are storing?
We're storing grid energy, and some of that is renewable energy, right? You know, it's whatever's in the system. We're pulling that energy when it's cost effective to do so. We're storing it, and then we're using it when it's expensive to buy electricity. So what we're storing reflects, in theory, our mix of renewable, 70% renewable energy. So it just doesn't happen to be co-located. I think the point is, it's saying storage, just thinking of it as standalone, would be taxed at this rate. And what section 2 here is saying, just to read that and make sure it's doing what you want it to do, how I'm reading it, it says it doesn't affect our projects right now because ours are standalone, but it's saying to me that it would be assessed that set rate if it is not connected to a renewable energy plant. So it says to me, if it's not connected to a renewable energy plant, it's going to be taxed at the 50 cents. That helps me know what it's going to be taxed at for those standalone projects.
Okay,
I'm
so
not
you
sure
just,
what it
you
means
need
for the
surety.
co-located.
Yeah, you need surety. So when you're assessing whether or not you can afford to do something, you've got the numbers. They're not
Correct.
out there. Okay, Senator Pearson.
I thought this was just simple.
That's
Jill,
what you told us.
my apologies. Jill, if you're reading this, does the storage accompanying a solar array pay more tax than if it was just a solar array?
Do you mean the current law?
Well, currently versus if this language became law.
Gosh, I didn't understand that that's what we were trying to do. So if that's what this is doing, my understanding is that we were trying to find output or reading measurement to do the assessment on so that it could be captured in it. And I think we wrestled with whether
it was the same output as solar, but these are
Sounds good.
slightly different beasts. So I don't know if the language that I'm looking at,
Well,
I'm looking at Abby's draft from, that's 4 pages long.
yeah,
Okay.
I think we got clear on Andrea's storage that is separate, but now I want to make sure we're being intentional about if it's co-located and whether it's clear to you at tax how we would handle that and whether that reflects what we mean to do.
Okay, Jill, we're waiting for Jill's answer, Senator McDonald, then
No,
I have
I'm
you.
sorry. Please go ahead. I'm looking at 2 different drafts and I'm just gonna try to get myself in order here.
Started out as simple. Senator McDonald.
Well, I was trying to understand that what the goal was in having the batteries, and they're 2 different situations. So in the case of the solar, solar has a fixed tax rate on its capacity, but sometimes on certain days, solar produces more electricity than there is a market for. Is that correct, Andrea?
Did you ask Andrea?
Yeah.
I don't know that-
Market, like if you're producing solar, it's gonna go into the system. So there's
And
times
sometimes
when
it-
it's more
does it sometimes
valuable than other times.
Produce more solar than the system needs at a given time.
Sure.
And so it's basically spilled milk in some regards. And if you put in a battery and save it and then release it after dark, it's making the sun shine at night, right?
It's catching that energy so we utilize it when it's more efficient.
Okay. So that's pretty much why we set a rate for, well, we set a fixed rate for solar, and this simply makes the solar more efficient, and more valuable to, customers, and more valuable to co-ops, and more valuable to local energy. So it seemed to be a no tax seemed to be consistent with that.
But there is the co-located. Yeah, I mean, a preferable tax situation for, it's a good thing to encourage, it's a good to do more of this. So the clarity is helpful.
Yeah. Okay. That's all given. So on the one that's off the site, which is collecting power from whatever you happen to be purchasing, that's more than you need at a given time, you can store it and use it similarly after dark.
We're not so sure it matters as much whether it's co-located.
Well, you
the
had,
solar's
I'm sorry, I
going
thought you
into
had
the
a
system
zero
and we're
tax rate
using
for
this.
one and a fixed different tax rate for the other.
That's what this bill does, yes.
Yeah.
But we don't have any of the co-located programs right now, so I can't speak to that so much, but
Okay, I thought the bill had a condition for batteries that were on the site with solar.
yeah.
Okay,
I think that's what,
well, it's helped to
I
make it
think-
more clear to me. I hope it makes it
Okay.
more clear to
well, I
someone
think
else.
that's,
Thank you.
I'm equally confused. I think we did start out with the co-located. Andrea's come in and said, yeah, but there are batteries that are not next to a solar array that,
It's okay.
and depending on how you define them, but as we put them up, we need to be able to estimate what our property tax costs or tax costs are going to be on these.
So you can get financing, yeah,
So, yeah,
yeah,
And
absolutely. Yeah.
she's just given us another species to decide how we want to tax. So Senator Bray,
And this is in lieu of a property tax, is it not?
yes. What's to give a definition as to because I think we found out when people started putting up windmills and solar panels, that listers had no reference as to how to define them or tax them or appraise them. And I think they're asking for the same kind of treatment.
Well, Andrea said that in her testimony that it didn't affect the tax on the underlying land. And I believe that the intention was to affect the tax on the underlying land and see that it not change from its current tax value simply because it has a battery on it. Is that the intention?
I
That
guess
was the intention originally.
so we're okay with what's in here. I just want to make sure you understand that what it does treat standalone storage different than co-located, and it's preferable. It's preferable tax-wise to co-located in our reading, and we're okay with that.
And you believe that
we think
it
it's okay.
freezes the land, the value of the land under this device at its current taxable value?
It seems to hold that harmless. Yes, that's
Oh, okay.
that's kind of outside of this
So-
whole thing.
Okay. No.
Okay.
So it does alter it does alter. Similar to solar. Thank you.
All right, I've got Senator Bray, then Senator Pearson.
So I guess this is a question for Ms. Cohen, and I'm wondering if we're not getting, I don't know, confusing ourselves over co-location or not. You want to put it in the most advantageous position in your grid, which is in essence one location. You could just say whether it's next to an array or not seems less important than whether it's better position from an engineering standpoint, whether that's at your somewhere. I don't know where I just don't want us to get so stuck on the idea that co-location with an array, because we're saying, oh, we could store the energy, the sunshine at night, that stuff. But it could be miles away that your substation is, and maybe that's the right place to manage the energy, right? So
Yes.
What I think
That's
the
what she
only
said.
thing I think Andrea is asking for is that we change we use solar panels based on their output. She's got, and she would like to have us do these storage facilities based on their rating, not, what was
Sure.
the other word? Their
Sure.
output, because the output varies like crazy.
Yeah.
But the rating is more static, and therefore she is a more predictable tax.
And I did ask around on that. I haven't heard anybody that had any objection. That's not the controversial part here, if there's any. But I actually don't think much of this is that controversial at all. It's just clarity.
Andrea is worried about that because there is a storage device on the land, that the land beneath it will suddenly become more valuable and is trying to stop that from happening?
No, I'm not. We're not
You're
worried
not?
about that. No.
Well.
No, it's the way we're going to rate her. The other thing, I've got Senator Pearson and then Senator Hardy. And I'm going back to eating my lunch.
Thank you, Chair. Sarah McDonald, that's one of my concerns, and I think we handled that in this draft. I'm looking to others to confirm, but on this storage solar co-location question, as I understand it, were that to happen, it would be based on the solar numbers. And so my question for you, Andrea, is the capacity increase? So if I have 1,000 kilowatt solar and I add batteries, does the capacity go up as we rate that project? Because this is, every time we take a tiny step, I think we're getting there, then it gets confusing again.
no.
I don't know the answer to that.
Because if we have a solar array that is taxed at X right now and we add storage, I should think we would all agree that the tax in some fashion should go up. And it's not clear that this language accomplishes that.
Right.
Right, so this is not these are not questions for Andrea. These are policy questions.
Well, but
We have to decide, and it's a policy question whether we want to have the ones that are co-located or not co-located have the same tax treatment or not. And we can say, no, we don't for a variety of reasons. Or we can say, yes, we do. We just have to be clear. And that was where I was confused because it seems like we were being different. And if that's intentional, fine. If it's not intentional, we just need to make that decision, and be intentional about it. And it's not really about, it seems like we've taken care of Andrea's concerns. It's about us making a policy decision.
Senator Hardy, the reason I asked the question was because solar is based on capacity, and the whole installation is based on capacity. So if you add the battery, are you adding capacity? That's the nature of my question, because it changes the denominator. So it is for an energy expert to tell us that. I agree with you. The decision is up for us. And I don't really know where to land quite yet.
I
It's not
think
adding
we're going to
capacity.
move along.
Adding value.
Jill, do you have anything to add at this point?
I know, I'm so sorry. I was looking at so many versions. Jill Remick from the tax department. And looking at the draft 1.3 that Abby has created that Andrea kindly shared, that's the language that we find preferable and seems to be accomplishing what you're trying to do. Currently, if a battery storage is attached to an existing, energy plant, it's taxed as one. It's under one UPG and it's taxed that way. So that's why we're having to address this, because this standalone battery piece is kind of a new thing. So I think based on my understanding of what you folks are trying to accomplish, this draft does that because it articulates, it adds specific treatment that is objective, not subjective, on how it gets assessed based on those figures. And I'm not one to say whether the 25-cent or 50-cent, if the folks are fine with that, that's fine with us. And I think this also makes it really clear for the local assessing officials on how they're supposed to treat these. And I think that was part of the original concern for the standalone storage units. Because again, we do have existing solar generation plants that have storage that are attached, that are part of that one entity. And so those are treated under that uniform capacity tax and were exempt. And so now we have this new methodology. We needed to come up with a new way to do that. So I think this accomplishes that. What I sent to you folks was just our current guidance for listers and assessors about how to value the land underneath, which I do think is also addressed in here. I think we can beef up our language on how we instruct municipal officials on how to value the land. It's supposed to be treated as normal in the few instances where there's that land, and some assessing officials apparently have been taking that highest and best use, which is what they are directed to do and how they're supposed to treat land a little bit differently under these arrays. And so I do believe there's a one section in this draft that clearly states it does not alter the existing taxation. So if it's already exempt, it stays exempt. If it's not exempt, it's not altering the value of the land. And my understanding was from the advocates for this law that they were fine. They understand they have to pay some property tax for the land underneath, but it was the unfair sort of, inflated valuation of that footprint that they were worried about. And I think we've addressed that, and we will definitely beef up our guidance for listers and assessors so they understand, because the idea is that if folks are paying that uniform capacity tax, and then they're also under this language paying this, output or rating based fee, then they're already capturing that income value that is supposed to be reflected in that property assessment. So I think
Which
we're
property
good.
assessment?
So for the statewide education property tax, that's set under the uniform capacity tax. But some municipal officials have been valuing the land under the facility, or there is a concern that the municipal officials would be valuing that land under that facility far above what it might have been before that battery was plunked on the land. And so I think we need to beef up our guidance on not making that adjustment and why. But I think there's also language in your latest draft that says it does not alter the valuation of the land for the purposes of local assessment.
Okay.
It has not been beefed up simply because it now has this battery on it. That's what your guidance now is. That's the policy.
That's what it will be. We hadn't addressed them before. There's only the one in Heinsberg. It's a new thing, but we will do that in response to this concern.
Okay, but I believe the league's concern was that we got a hill over here across the road from my house. It's got a full solar array. Are we freezing that land value at what it was when the solar array went up? And 20 years from now, it is still going to have the same value? Or does it appreciate over time as similar? And I thought it was as similar lots in town, i.e. vacant lots, rise 3% a year or go down 3% a year, depending on the year. That
So
that
the house
it
was
was
up. before
appraised
49.
at
You're saying
the
you're,
same rate as similar lots in town. And it wasn't altered because the solar array was on it. Am I correct in that?
That's what we're aiming for.
Well, that's
does-
the way they're taxed now, right? Not for batteries, but for solar arrays.
Well, but this has shifted, and there have been towns that have cranked up the value, and those solar developers have been contesting it and actually coming through.
Okay.
That's why some clarity, I think, and I've emailed Karen Horn, tried to get assurance from her that she supports this, because different people have told me that she does, but she's never told me that. So that's what we're aiming to do here. This is actually something that we think all parties can agree to and can add some clarity and some certainty, as Senator Brace pointed out.
Okay. I'm gonna go, if we have no other questions for Jill, we're now once again running overtime. We thought this was a simple little bill, so Senator Bray.
I knew what I wanted to ask about 42 seconds ago, but let me see. Right. Oh, it's that, part of the whole construct, as I understand it, is these are all temporary structures. You can pull up an array and leave. You can pick up a battery and go. And it's not like building a building there. And they have finite working lifespans. And I think that was part. And then we're also seeing it as consistent with state energy policy, like make it more affordable to build out a more efficient grid, because it's a public good. So I think
I think that's
certainty
probably
is one good
why.
thing, and a relatively modest and steady low rate is another good thing.
Considering that we tax mobile homes that are left in a park over the winter as real property, I think it's more the latter. It helps state policy. I want to go on to Greg and give him a question, and then I'm going to have to move us along unless we have a question for the witnesses. The rest of it is we've got to noodle it out for ourselves. So Greg, you help us in any of this?
On taxes? No, I can't help you
No,
at all.
all right.
No, sorry. But I can bring up other stuff about application processes and things like that to confuse things a little bit further. So I'm Greg Faber with the Public Utility Commission. And as you may remember, I testified a couple of weeks ago along with Agency of Natural Resources and the Department of Public Service. And really, there's only one small section of this bill that I want to see altered, or that the commission would like to see altered, and that's on page 9 of the as passed by House version. It's in 248 sections, small u. And basically what this language does at the end of this subsection here, it basically says that the commission has to issue a certificate of public good for a storage facility within 30 days. But if we don't do that, a CPG is deemed issued. This this is unusual. In fact, this is the only time I've ever seen this, or it's the only instance of this that exists in statute today. I don't see any reason why solar facilities need to be treated differently than other 248 projects. There's just no reason that they need to be moved faster than other projects. There's no urgency there. It would be much better to develop a simplified application process, as the rest of this section directs, through the rulemaking that this bill contemplates in the next section. So my ask to the committee is to remove the language starting with the third sentence in subsection U.
Subsection U. All right, committee questions? I'm not finding any of this, so. Senator Pearson, yeah.
Greg, I thought when this came over from the other body, you had supported it, but maybe that's I'm mistaken. But I thought we did have some timelines that were similar, particularly for solar and the little
Just the 15s.
the small array. So all anyone has to do, it seems to me, in this language is say, no, we need some time. Why is that such a heavy lift?
Well, it would force all the other agencies to, it would force them to issue objection letters rather than actually review the process in a timely manner. So yes, ANR could come in and say, oh, we object to it. We haven't had a chance to review it. That's not a good way to review projects. It's better to have either an advance review period where ANR could comment on the project in advance of the application being filed, or set a shorter timeline for review by all the stakeholders, towns and neighbors, folks like that, especially lay people. They're not going to know all they need to do is file an objection. So it's better to have a process laid out through rulemaking with all the stakeholders. Everyone knows what they're getting into at that point. And honestly, these things are pretty small. You saw the picture of them. They look like shipping containers. I'm sure most of these things will be issued a CPG within 30 to 45 days. So it's tough for us to have this in statute where if something falls through the cracks, all of a sudden the CPG is deemed issued when we really haven't reviewed the project, or other agencies haven't reviewed it.
Right, and then we're going to wrap this up.
So, Mr. Faber, the rulemaking that you're describing, it follows, provides an opportunity to address this, right? I mean, you're talking about, for instance, you could set timelines for an opportunity to review, or pre-filing, et cetera.
That's right.
I'm just, I'm living on the LCAR end of things. I'm appreciative of having an orderly process for everyone to go through. The pushback I hear is once in a while there's a project that seems to get hung up going through the PUC process for longer than anyone would imagine. And so I don't know if these are going to be vulnerable to that as well. And if you're saying, well, the rulemaking will be the durable solution to having timely review of these proposals.
Yeah, I mean, there's always some projects that get hung up for various reasons. However, the way this is set up, it forces people to just object to it, and then there's no timeline at all. It'd be much preferable to have an established timeline whereby there's advance notice. Utilities are looking at these things before they even go into place. ANR is on notice that they're only going to have a couple of weeks to comment on this thing. That would definitely help and avoid those situations where things do get hung up.
Okay. Are you imagining that there may be private, I don't know how you would sell the service through a PPA or something to a utility. Are there private developers who are thinking they would like to put storage in and sell that service, just like they would be selling, solar generation to an adjoining utility, the DU that they're in?
It could be. Another problem with this is that we just don't have a lot of experience with battery storage. That's what the rulemaking is going to give us an opportunity to gain. We'll be able to talk to the stakeholders, see what the intended uses are, and then we'll be better able to set up an application process that works for everybody.
Right.
I have to move us along. So, Greg, what you're asking for is take out if you don't get a certificate of public good next number of days,
right,
unless you object to it, the proposal, then it's automatically given. You're saying that's going to just force you to just put object on everything that comes over. If your time frame says there's no way, given the workload out there, that we're going to get this out. Once it's objected to, it can drag on forever.
That's right.
And that the 30 days that's in this is not realistic, but that you would like us to charge you with developing rules that would ensure an efficient and speedy resolution of these applications.
Right. The rulemaking already requires us to do a simplified application process. So
okay,
I think everything else is
Just
there. It's just
strike
these
it.
last two sentences that need to be struck.
all right. Senator Pearson.
I guess I'm not understanding why the rulemaking wouldn't give you permission to set up the timeline, set up the off ramp if you do object, and not have it be what as you've complained, that there would be no process. Set it up in rules. I guess I don't understand. Don't we do this similarly for telecom projects now?
No, we don't. In telecom projects under 248A, there are a series of guidelines. For type A project, PUC, you shall issue an order within 45 days, let's say. That's one part of it. However, there's no consequence to that if we don't hit that 45-day mark.
I see.
CPG is not deemed issued. That's the problematic part. It's one thing to say, yeah, you should get this done within 30 to 45 days, and we're fine with living with that. But when you say it's deemed issued and nobody's even looked at it per chance, I mean, it could happen. That's the problematic part for us, Senator.
And that was the big concern I remember with the 240As, is that communities didn't have enough, things happened too fast. They didn't have enough time. So if you put in something like, it's deemed granted, once it's granted, the communities that may just be catching on to this thing is being built in the town square are up a creek, because we've said it's granted because they didn't get to it.
Right, our hands are tied at that point. So
Yeah. Everybody's hands are tied.
Yep.
Okay, I'm going to move us along. Senator Bray, this is it.
Okay, quick question. So I'm just noticing in this section U, when we're talking about any storage facilities, they're talking about, we're back to capacity and kilowatts or megawatts, not rating and megawatt hours or kilowatt hours. So is that intentional or not?
capacity is the same as rating. So capacity is how much the battery can hold. It's different from output. That's what Ms. Cohen was trying to make that distinction. Output is very different than the actual capacity rating of a battery.
Right.
So we're fine with capacity. Yes, that is intentional. That was, this is the department's bill, but the way it's set up, it's based on the capacity of the battery.
Okay, I just want to make sure we're sticking with apples and apples.
Yeah.
The last thing I would chip in is, if we've only had one situation so far, I'm inclined to let the rulemaking go forward. It seems like we're trying to cure a problem we haven't had yet.
Yeah. It's called preventive medicine.
Okay.
Okay, I'm going to move us forward. Ellen, do you know what needs, because apparently there's a new draft from the first draft that we saw. I'm not sure how much is in that second draft that's been asked for. Does anyone on the committee object to putting in the capacity for the storage as their taxing base, or object to taking out that hard line, date certain, and maybe you want to beef up the rulemaking statement faster? I just want to get us a working.
Yes, 3
model.
questions, Madam Chair.
Yes,
So
that
can we
come
take them
back.
one at a time?
Well, I don't have time to have lengthy discussions. I've got Senator
No, I do. Would you
Pearson.
ask the
Let me
questions one at
have
a time?
Senator Pearson. I will, if I can remember them, I'll ask them one at a time.
Well, I was going to say the same thing. The only one that I wonder about is the timeline, and could we at least stipulate, a desire to see it within 30 days or 45 days or whatever seems appropriate.
I don't think stipulating the time that they shall do this. But if we have another pandemic and they're out doing health
I'm agreeing
care
with you.
stuff,
I'm
I mean,
agreeing.
yeah, it's the automatic assumption that it's granted.
I'm agreeing with you, Madam Chair. I would
Okay,
just like
so
us-
does anyone object to taking out that automatic?
Well, I would object to just taking it out. I'd like to substitute and say, permits shall be, or,
Yes.
the ideal would be 30 days, 45 days, somebody pick a number.
All
So
the
it's not
time. Do it all the time, okay. Does anyone object to picking a number and saying the department shall act or grant or whatever the appropriate term is within, pick a number, days? And I'm not, to take action, 60 days to me sounds a little more reasonable than 30. If you want 3 different departments to review things. Anyone object to that?
No, but
Okay.
what happens if it doesn't happen? I guess that's what's a little
Nothing.
confusing.
Well, the same thing that happens if they don't get something out for 240A or B, or the hearings. If they don't, I assume that there can be legal consequences if somebody's aggrieved.
Did the PUC object to this in the House bill?
It isn't in the House bill. This is our bill.
No, when it,
Yes, we did, Senator.
Oh, okay. This is in the House bill? I guess the other energy bill. All right. We're just attaching that to this one.
But what is I thought I heard either Greg or someone say that the standard was 30 or 45 days. Is there a standard for, because 60 days seems like a long time to me. I mean,
45 days is one of the lowest standard under 248A. I was using that as an example.
as an example, okay.
Those are very small improvements to existing telecom facilities, wireless telecom facilities. So similar in some ways. So 45, 60 days, that's probably more reasonable than 30. Yeah, I would say 45 to 60.
45 seems good. These don't seem that complicated, at
I've,
least.
I've got a 50. This is going to be an auction. All right.
I can bring you a draft. You do have some
Okay.
other recommended changes that were proposed by Mr. Murray, but then also by the Department
Yes.
of Public Service. So we may need to have another conversation.
Okay, no, we're gonna have another hearing. I'm just trying to get answers out of the way so you can draft. Senator Hardy.
Thank you, Madam Chair. So in relation to the other issue, that was, I think, one of your 3 questions about.
One was the taxing based on the energy capacity rating
Correct.
rather than on the output, because output varies widely.
Right. So I just wanted to say that Jill, thank you, Jill, for your clarification, because that, if she's still here, that was really helpful to me to understand what we were doing here and that conflict between something that's adjoining or not. But you said that you were looking at draft 3.1, and the one I have is 5.1, I think. And or 1.5. And so I guess that's my question, is which one are we looking at? And what is the difference between 1.3 and 1.5? And maybe Abby knows.
Yes, I'd be happy to just jump in and answer that. The difference between 1.3 and 1.5 is that 1.5 has the rating. So you're talking about switching to capacity or rating rather than output, and that's in 1.5.
Okay, great. Thank you. And then I'm fine with that then.
Okay.
Madam Chair, I'm not, because I still didn't get an answer that I understood from Jill, despite her hard work. And it has to do with the underlying land. And the reason I asked the question, Madam Chair, is because I reported the bill and understand the various questions. And when we tax the land under the storage facility, what is the provision in the bill about the assessment on the land value beneath the storage facility? And the second half is, and as similar land in the town is appraised at higher rates, is it frozen, or does it go along with the year by year assessments?
Abby, is that
Yes,
more
would you
in
like me
your?
to-
Yeah.
Certainly. So I'm not sure I actually introduced myself. For the record, Abby Shepherd, Office of Legislative Counsel. For the first question, in the bill, the provision that specifically calls out underlying land is in the uniform capacity tax. So that's stating that
In lieu of the tax on the underlying land.
it does not impact property tax on the underlying land. That's the new language that's being put in here. So the UTC is not impacting either any exemptions that apply to underlying land or any taxation of land underlying solar generation facilities. And then there is another provision within the property tax chapter and the valuation of these different plants. So you have the existing treatment and the existing valuation of renewable energy plants, and there's new language that creates the 25-cent per kilowatt charge. That is, again, it does not impact the underlying land.
Line value of the land.
Correct.
So what is the value of the land once you put the facility on the land?
The same as it was the day before, is my
Okay.
understanding.
And 10 years from now, it will be the same as similar land in the town that doesn't have such a facility on top of it.
Correct.
And it's not frozen at its current rate.
No.
Okay, that's
No,
very
that
clear.
this bill
And
does
thank you
not.
very much. And
Okay.
I now.
All
and
right,
that-
I've got to
that's
move
on the
us
record.
along. We
Excellent.
are way behind.
Yes, we are,
again.
Madam Chair.
Ellen, you've got enough to draft, and we will get back to a markup or vote. Okay. We're going to move on to the changes that affect the revenue of the state. Steve Klein, Mark Peralt, and Abby is here too. Thank you, Jill, and everybody. And Graham's here. Okay, who am I looking for? Steve, are you with us? Your name is with us. Mark's name. There's
Yes.
Steve.
Hi, sorry.
Okay.
Yeah.
So this is.
I'm just trying to figure out how best to organize this. What I could do, and I'm not 100% sure what would be most useful. So what I can give my little spiel or take about 5 minutes to talk about the whole revenue situation, and then you can just ask questions, or do you want me to hone in on something in particular?
I think the big question I had was, the revenue situation, how much of the money at play in this bill has been spent in the budget?
Okay, so, and I'm going to turn to Graham afterward to sort of, he can go in the detail of this. But we basically, the administration, when they built the budget, built it on current law revenues plus about $1 million. It was pretty close to the current law revenues. They had some adds and they had some deducts in tax cuts and tax increases. The House basically was in the same ballpark. What they did is, but they're on the revenue side, they had more money in the first year and then declining money in the later years. And so we're all sort of using, this is a very unique year in the House because the budget passed before the revenue bill did. And we basically all just sort of assumed we'd have roughly the revenue of current law. And so that's sort of the starting place we all used. And as you know, we're in a really weird environment because the forecast done in January was built with a lot of assumptions. It was built with the assumption of they had the March of the prior year, the federal relief package, the December relief package was just happening, and we really that wasn't totally incorporated in the new forecast. And the March forecast of this year, the federal money this year, was not incorporated. So you have a situation where, and then the other thing is they had made assumptions about how long it would take to get the vaccination in place. And I think it's happened quicker than they would have forecasted. So what you're seeing right now is a fairly dramatic increase in state revenues above what was anticipated. And we're seeing this fairly large amount of federal revenue. So we're budgeting in a context where for FY21, 2, and probably even 3, you're going to see more state money and more federal money than we've ever had. And it's going to be a fairly major upward pressure on revenues in that period. Now, one of the dilemmas is the two are going to go down at the same time. There'll be a point where the federal money will start, unless they're going to keep doing this to us forever, which could happen. There will not be this, onslaught of federal funds forever. That's our assumption. And the second thing is when that starts happening, you're going to watch contraction of the spending in the economy, because we basically are looking of, when you think about the money received, this may be too general for you. I just want to flag it, but we received between the CRF of 1.25 billion, the 1 billion of ARPA, the close to 600 million that went to schools and local communities, a lot of money directly to reallocate, but also individuals and the PPP and the UI assistance produced another, $4 or $5 billion out there. So when all this starts contracting, you're going to see an impact on sales tax, on your corporate tax, on personal income. So what we're all doing is it's a little bit like, I want to say, I feel like a fiscal person who says the sky is falling, a crying wolf, and everything is so good. But you also have to realize there is going to be a time, if we built on this, multiple time, 2 or 3 year revenue, a spending plan, we would be in terrible shape, 3 years out. So what you've seen the administration do is they talk about this as a once in a lifetime opportunity to build a stronger economic situation and to really sort of make one-time investments to really improve things. The Senate really and the House followed suit, and they did not increase their base spending that much. And that's been a real issue. So we have money, but we are really, what we did and what they encouraged the House to do, and I think what you've been asked to do, is to not reduce revenues, not necessarily, grow them, but to think about it in terms of 2, 3, 4 year period where we are in before this all happened, we were in a very low revenue growth period that we're hoping that by utilizing the federal funds and the state funds effectively, we can sort of live in a lower growth period down the road. But this money is basically a very dangerous thing. We're worried about 380 million going to schools. If they build that into an ongoing obligation, you'll feel it in your property taxes. The 180 million going to cities and towns, same issue. To the extent they can use it for one-time expenses, we're in better shape. So this is sort of just a background level. A long story to say that we basically assumed the revenues would be as forecasted, ongoing revenues, knowing they're going to go up, but knowing that's a temporary phenomenon. So we're hoping to keep, and I think you'll see is in the House, when they added property transfer tax to cover the cost of the manufacturing tax credit, they did so in this context that we're going to keep the overall revenues roughly level. There was definitely in the later years, and the House made some decisions which reduced general funds, which are problematical, but it's hard to me to speak authoritatively because we're all talking about a shape of a future which we don't know. So I don't know if that even has any relationship to what you were wanting to hear, but that was sort of my.
Okay, so the House, I know the one thing that's had some concern is the surcharge on business property transfer.
Right.
Because I'm not sure $1 million property transfer in business is as large as $1 million house. But there's some mechanization to get this, because the machinery and equipment would normally go to the ed fund, right? That's a sales tax. And this is which would go to general fund, but I thought they had worked it so everything went to general fund.
Well, and I'm going to let Graham, do you want to explain how the manufactured housing thing tied into the? Oh,
no, I'm thinking about the manufacturing. The manufactured housing is a tax credit. That's clean. It's the manufacturing. Is that in this bill or in another bill? The machinery and machinery and equipment that's attached. Is the conveyor belt part of, taxable if it's attached or not attached to the production equipment?
So Graham, can you take on that one? Because I'm more.
Right. Yeah. Graham Camp from the Joint Fiscal Office. Madam Chair, you're right. So it is somewhat confusing. There are essentially three revenue items in this bill. There is the tax credit for the use of manufactured homes. That is a general fund expense. There is the property transfer tax surcharge on homes with the value over $1 million, homes and properties, I should say. And then there is the manufacturing machinery and equipment exemption expansion. So there are, I guess, two manufacturing things in here, even though one is manufactured homes and one is manufacturing machinery equipment. The two general fund pieces are the property transfer tax surcharge and the manufactured homes tax credit. And then in the education fund, there is the manufacturing machinery and equipment exemption expansion. So there are two funds being affected here. The property transfer tax surcharge is sort of in place to help offset the cost of the expansion of the manufactured homes credit. And then the manufacturing machinery and equipment exemption sort of sits alone in the ed fund as a revenue decrease of about $900,000 a year. So those are the three things that are in this bill 437 that I guess is sort of under consideration for the committee.
Okay. So I'm going back to find the bill here.
Madam Chair, are we combining these two bills? Is that what your intention?
No, this is a standalone bill. And we have the miscellaneous tax bill, which will have a lot. This is a standalone. It's an up or down. I think The other things that are at play that affect revenue are in the miscellaneous tax, or there's the PPP exemption, which we have to make a decision on, and the EITC expansions, all of which will affect the revenue. I don't think this year, well, the PPP would be in this year's budget, and then the EITC, I think, would be next year's, but I'm not completely clear. And I think that's what's been frustrating, is trying to find out what.
Let me just answer one thing. The EITC and dependent care are FY22 expense. And if you make the change, that we're treating that as, the thinking is we're treating that as a one-time cost, even though it's most likely going to be multiple years. At this point, it's viewed as an FY22 cost of about $8 million. What we're going to do, and this is, as you know, when the bill left the Senate, the budget, it had about 28 million general fund in the bottom line. And so what we would probably do is reserve about 8 million of that general fund to offset the cost of of your decision, if you do it, to do the EITC and the dependent care. So you would not need to fund that. We would fund that from the extra money that went over in the general fund. And the theory is that it's there now, we know it, we can book it against your cost. And then what'll happen as we've talked about earlier, is the revenues are likely to go up pretty substantially. And then we'll deal with the out year. That'll be an out year pressure. So this is not a perfect game of, unfortunately for us, there's no way to know what the future holds, other than we know that we need to keep expenditures somewhat under control, because this isn't a forever revenue. But that was our plan, was to handle that with one-time money already in the bill. So you wouldn't have to pay for the EITC dependent care increase.
About the PPP exemptions.
The PPP, go ahead, Graham.
Yeah, the PPP, not exemption, the treatment of PPP loans for the forecast, they assumed that they would be tax-free. So if the committee makes the decision to tax PPP loans in tax year 21, 22, 23 going forward, it would be a revenue up against for the budget purposes and against the forecast. If you decide to make it tax-free, there's no revenue impact because that it was assumed in the forecast. Is that clear?
Okay, and it's the year that they get turned into a grant, right? So it's a 1-year hit per business. A business you can't say I got $100,000 loan and I'm going to pay my payroll for 3 years with that, can you?
No, they have a limited window to make.
Right. So it's a 1-year hit per business.
Per business, yes. The impact for this, not impact, if the legislature decides to tax PPP loans, then the impact spreads over a couple of years, because some businesses will have their loans forgiven in 21, some in 22, some in 23. And so there is a tail there. But again, if the committee decides to make these tax-free, there's no revenue impact per se, because it was already assumed in the forecast that was what the tax treatment would be.
In the forecast. Okay. All right, that's right. We're all dealing with the forecast, not actual dollars. I've got Senator Pearson, then Senator Sirotkin.
Madam Chair, I'm sorry to do this because I'm certain it's been covered when I had to run around for a second, but it's probably worth repeating anyway. Graham, could you, as I understand it, the tax credits and exemptions in this bill were not reflected in the Senate budget, right? And or maybe I put it, H437 was not reflected in the Senate budget, but there are some ups and downs. Can you give me the bottom line on what this bill costs, and then, Madam Chair, maybe help me understand what?
I think there's two things. One is the revenue forecast, and I think that's where Graham is saying in the revenue forecast they didn't assume any tax on the PPP.
So there are two issues. Let me answer Senator Pearson's question, and maybe I don't. On the side issue, what you decide to do with the PPP, the EITC, all that's out on the side.
I just want to know the level of the bill.
all the other changes, the tax changes you're considering, we assumed that you would end up about where current law is. So in other words, if you were to put in place a tax reduction, you would offset that with a tax increase. I don't know if that helps or not. Probably not.
Not quite.
Okay.
If H 437 becomes law,
Yep.
what's the cost? Because it's not in the Senate budget.
So the H 437, and Graham, you're going to jump in on this in a minute. The PIT, the increase in the surcharge in homes was about a $2 million up. So that would have brought in more revenue. But that was designed to offset the manufactured housing credit, which is a down of about, not as big a down of 0.25 and 0.5 and 0.75. So you would end up being net positive about 1.25 million. Is that close, Graham? Or?
That's right. So it is odd because the budget moved before the revenue bill was passed. So what Steve is essentially saying is that when they were building the budget, they assumed that the revenues would be the same, roughly the same as current law. So if you enact any sort of tax decreases, you have to offset it with an increase. This bill alone in fiscal year 22 for that budget, it generates $1.85 million for the general fund on net. And the reason why that it's sort of in the positive in the first year, at least for what Ways and Means did, is because that manufactured homes credit increases every single year. It ran up to 1.25 million. And so they wanted to sort of have those two relatively close when they passed the bill to sort of in the out years to make the tax cut here, the credit, be equal to the tax increase, which was the property transfer tax surcharge.
And then thank you. So this bill on its own actually increases revenue, doesn't create a hole.
Right.
We have also been talking about the expanded downtown development tax credits and the neighborhood development tax credits. That's also not in the Senate budget, as I understand. That, if we added that to this, starts to create a hole. Am I right?
Depending upon the size of your expansion, yes.
But just in the House passed version, we're starting to get into a hole. Then when we add PPP, although that's out of the revenue. Okay.
Well, that's going on miscellaneous tax, but that's still.
Well, it's helpful to have it by bill, but we have to understand the full picture.
Right.
Thank you.
Then there's the
PPP is out of it.
EITC.
That doesn't create a hole. Yeah.
But we have, what is it, 8 million in the EITC and dependent.
Right. Those do not create, that creates a hole, a temporary one-time hole, which we were going to offset with one-time money. So I think you don't have to find the money for that. That would not be on your balance sheet.
Okay. Senator Sirotkin.
Thank you, Madam Chair. So Senator Pearson stole my thunder a little bit. I wanted to know the net gain from this bill, and he also stole my thunder because the increase in the downtown tax credit came out of my committee unanimously and passed the Senate, I think, unanimously. And I don't know, I want to hear from Joint Fiscal, what has happened to that in the House?
Okay. Well, do you want to Mark? Sorry, Graham, do you want to talk to that one?
I'm trying to remember the bill number that was in, but as it stands right now, there is no increase in the downtown tax credits in the House that I'm aware of.
Correct. Yeah.
Being considered.
Nations took it out in the Senate, I believe.
No, they didn't.
No, it was in the House. They basically did not include that in the House.
Passed this committee and it passed the Senate.
Mhm.
And so I don't know why we wouldn't fight for the Senate position on that.
Okay, but that's not from this bill.
I thought there was an H bill that
Very
did
well
that.
be in this bill, because this bill actually has some extra money in it in terms of gain from the property transfer tax.
Well, we haven't decided we're going to do that yet either. And if this is going to get bogged down, we don't have to pass this bill.
I don't know that it's getting bogged down. It's defending the position of the Senate.
That's what you do in committee of conference, which is where I assume this is. You've got a bill with that on it. The Senate's position is in the you need to defend that in the committee of conference.
Well, there's many ways of going about it.
Well,
We're getting parochial here for a second.
we are. I'm trying to figure, I just needed to know that we could do this bill and that we were not negatively impacting the budget that we just passed, that it sounds like the surcharge is on the property transfer tax, is being used to offset the expansion of the machinery and equipment tax. Originally, I was told it was going into the budget to do something with the clean water transfer.
No.
Okay, it's not. All right. So this bill, as far as the budget is concerned, is clean. If we don't do all of the property transfer tax or any of it, then we will create a loss with the machinery and equipment tax. And we know we're going to create, is it 15 million is it 5 million a year for, I remember the chart, but it goes up. It's a $5 million cost, but that credit can be claimed for 5 years. So that's the biggest cost, I think, here right now.
That's the downtown.
So I'm not sure. The manufactured homes credit.
Yes.
It increases by $250,000 per year, the cost of it.
Right.
This expansion costs an extra $250 a year up until fiscal year 26, when it sort of plateaus at that. So that once it's fully phased in, they're 5-year credits, and all those credits from the previous year sort of stack on top of each other. The cost of this expansion is a reduction in revenues of $1.25 million. So based upon the forecast for the property transfer tax, we estimate that the property transfer tax surcharge in sort of long term will be about $1.9-ish million. So in the long term, these two items sort of net each other out.
Okay.
In the short term, it looks like, and it is true, in the short term, the property transfer tax surcharge overweights the decrease in revenues from the manufactured homes credit. You have $1.85 million in the first year of additional revenue generated. But in the out years, those two things become equal once the manufactured homes credit is phased in. So in beginning years, you do have extra revenue per se, but in the outer years, you don't have very much.
Okay. Senator McDonald.
Madam Chair, I'm astounded that we have been able to actually, so many of us on this screen, kind of put all these numbers together without having them sit like we usually do with a chart where we can look at what's referred to. And do you, Madam Chair, plan to sit down with the Chair of Appropriations and maybe have and discuss how we might blend these two issues together in a way that we can all understand, and we're not pulling in different directions? Or has Mr. Klein been sent to broker or bridge this?
Until today, the Chair of Appropriations and I have met weekly. Today I met with you. All y'all.
There is a chart, by the way. We can put that up if people want.
So it's so, Madam Chair, I think we all know that we have some issues to deal with, and rather than, do you plan to speak to the Chair of Appropriations and maybe together?
Right now, I have nothing to speak with the Chair of Appropriations about.
Okay.
I mean,
we think everything balances?
From what I have heard, if we pass this bill as is, everything balances. If we play with it, there is a danger and it balances. Plus, there's the other revenue issues that I could put them on here, we could, or I would plan to put them on the miscellaneous tax bill. But there's the EITC, Earned Income Tax Credit expansion, the increase in the child care tax credit, and the PPP exemption or
so
lack thereof. I think
Well, the
what I've
exemption is
heard is
assumed,
we
is it
can
not?
do all of those
Yeah.
and that they have been covered in the budget. There is a plan to cover all of them. I have told them I thought this committee was favorably disposed to EITC and the tax credit. PPP
Exemption.
was a little iffy. Where we get into trouble is if we start throwing other things on these bills.
So I'm hearing there are a lot of different moving parts that we have a path forward. If we don't do things, that Senator Sorokin's going to be disappointed in the plan that we have before us. And there is, but if we could see that on, and this is contingent upon what this committee does on other bills. Is that correct?
I think if, as long as we go forward with what is presently on the table in both bills, we are not going to cause a major problem in the budget negotiations, which is where the budget is right now. Okay.
Well, that's a hopeful thing to hear.
Okay.
Thank you. Thank you.
We have other questions at this point. Senator Hardy.
Thank you, Madam Chair. Steve or Graham, one of you mentioned a chart, and I'm looking, there's the revenue tracker of money proposals. Is that what you're
That's
talking
what we're talking about. Yeah, that has it
Okay.
all in one sheet.
And as of April 19th, is that the most recent one?
That is the most recent one. I guess there would be two. So the fiscal note, I would encourage the community to also look at, because that gives you what's just in this bill.
Yep.
And then the revenue tracker is sort of a document that we keep in our office that tracks tax changes in each body. And so that can give you a sense of all the sort of moving parts that have passed the House that will come to the committee to get a sense of their size and scale. But again, I would say that this year is a little bit different in that, some of these bills that are in that revenue tracker moved before the budget or moved after the budget moved. So a good example is that S53 that passed in the House, all those corporate tax changes, the cloud changes, stuff like that passed after the House passed its budget. And so, you'll see the numbers there. It'll give you a good sense of what the ups and downs are. But it is a little bit weird in terms of if you wanted to add something to say 437 or 436, it's sort of a different question about whether the committee would have to find an offset for that or not.
From the budget point of view, if you look at, I don't know if you have this up, but line 13 does track sort of overall on that document where the governor was. And you can see they were up $1 million, down $1 million, down $1 million. The House was in the end, up 5 million. And we did not book that in this year because we figured we'd wait till in the Senate anyway. We don't know where you're going to end up. We tried to keep it along the concept when we talked with the chair was that we'd be roughly around the existing forecast. So the House cut in the subsequent years a little bit. And so this is just our attempt to put it all in one place.
Okay.
Thank you.
Senator Pearson.
Steve, just to go back to stealing Senator Sorokin's thunder, on the downtown tax credit, as an example, that did pass the Senate.
Yeah.
And so I assume therefore that cost was reflected in the Senate budget, correct?
Yeah, that's a really good question. I actually am looking at this tracker and I'm going to ask Graham. I think we probably should have kept the 1.75 negative in the Senate line. Because are there other things, Graham, that's passed that should be in the Senate line? Or is that?
Yeah, I need to make sure that that's the case. I need to look at the bill numbers again. I could be forgetting that. I'm trying to, I remember there's S101, which passed the Senate, which struck the language for the dollar amounts. But I'm trying to remember which bill the downtown tax credit expansion was actually in, so I can confirm.
I think it's S33, Graham. I'm pretty sure. And it looks like it passed Commerce in the House and is now in Ways and Means.
Okay.
Yeah, so we would need to carry, and you're correct, Senator Pearson, we should carry the Senate passed numbers in the Senate column. And that would be a negative 1.75 the way you passed it. And then we should look and make sure that there's nothing else. I think that's it, in which case you would show up on your line. Overall, you'd be minus 1.75. And that should have been reflected in that. To be honest with you, it's not like you didn't pass the revenue bill before the budget. So like in the House, when there are probably going to be differences, we assumed we'd have basically that much money, but we're not in that exact position that we didn't build the budget with to the penny because we didn't really have the penny. So I would have to say, when I go back, I think they assumed, well, knowing what they assumed, they assumed they had actually a little more money. That 1.75 will be a negative. We'll work that out in conference. I mean, we basically assumed it was about even.
My interest is a little bit different. I'm just trying to understand if we have to wrestle with our friends, quote unquote, across the hall or not. And it sounds like,
yeah.
Thank you.
I mean, all I can say is if you get within $1 million or $2 million of the current law forecast, you're basically in the break-even point. And in this year where so much is up in the air, I think you just have to do what you need. Your committee, you were in that range.
Okay. This point, but if we pass nothing, if this bill did not pass, nothing would be seriously impacted. Is that
correct?
The budget.
Yeah, you'll be in the minus 1.75, 1.75, and then if you don't pass the manufactured housing credit and you don't pass the property transfer tax, those two numbers will not be. That would be a net positive if you pass both of them, a small one. Graham will just be adding everything to the tracker. And our hope is you come up pretty close to, revenue neutral. But
okay, I'm at this point not very reluctant to talk about adding other things that are already in play to this bill. It's a not passed bill, and the chance that it will make it through, if the other body has said no, then it's not too likely. There's nothing vital enough on this bill to make them say yes if we add something to it. This is not a must pass. So
do we have reason to believe they've said no, or they just haven't gotten into it?
I don't know.
Yeah, maybe we'd be doing them a favor by making sure they can get to it.
What are we specifically talking about? S33, the downtown tax credit, or are you talking
downtown tax credit?
I see.
I guess I'm.
I thought the Senate appropriations had said no.
No, the bill passed the Senate,
Okay.
and I'm at a loss why something that we worked on and we passed can be effectively killed by the Ways and Means Committee, and we have no power over that.
Happens all the time, Senator.
Well,
Why we have a bicameral legislature.
Although
We are
some-
not, by the way, and I'm under considerable pressure. This is the third or fourth time we have been sent the cloud tax and we have never taken it up. And we have a major rewrite of the corporate tax and we are not taking that up unless we move things along very quickly. And they are very important. The cloud tax is very important to the chair of Ways and Means. Now, if you stuck your tax credit on there,
Right.
if we could get it done, you might have something. But I think at this point, it might just annoy them further.
I don't see it that way. I mean, maybe it'll annoy them, but they're annoying us at this point. I mean, I don't understand how the Senate can pass a bill. And why don't we, as much as I like the manufactured housing thing, why don't we either split the money to these two programs or substitute what we've put in there for the use of the property tax increase? Why do we have to
Well,
say yes to
Senator,
them and no to us?
I know that's very important to you, but I'm not willing to
According to the Senate.
sacrifice the manufactured home tax credit to give banks a tax credit for downtown. I would much rather see that money go to help put housing and, well insulated, affordable, climate friendly housing for folks.
I'm not sure it has to be either. And it sounds like, at least in the first few years, is extra money.
It's not. Senator Hardy.
Well, at the risk of annoying the chair, I'm going to say I agree with Senator Sorokin, and I think that we could put this on this bill. It doesn't necessarily mean it kills the bill. It just means it goes to conference committee, and then we talk with our friends in the House about the overall bill. And maybe it ends up coming out in the end, or maybe we all say this is great and it stays in, or something else comes out. I think if it passed our chamber, and it did, I think unanimously, then it's worth trying to fight for within the context of a.
At this point, I'm going to move us on. I think it's a very dangerous precedent to set. What goes around comes around, and we might find some things we want held up until we pass the cloud tax. We have independent bodies which make independent decisions, and this is not a must-pass bill. So I think we are supposed to be doing miscellaneous tax 13 minutes ago. And I'm going to move us on to see if Abby can walk us through miscellaneous tax so we remember what's in there very quickly. And then we're going to be taking testimony on that for the next 2 days, and then 2 or 3. And then we'll start cleaning up the other not must pass bills that they can hold over, and maybe things will work out. So Abby, Steve, I don't know who's staying for miscellaneous tax. If anyone, can you give us a quick walkthrough? And then as soon as Maria comes back, we're going to.
I think Graham from our staff would be the one carrying.
Okay, yeah, I think so. Senator Bray.
I just want to get a bill number, please.
This is miscellaneous tax.
It's H436.
436.
Thank you.
Yes, I realized I have asked Faith to put a lot of documents under my name today, so.
Have about, I don't know, you ought to go into health and welfare if you want to see a lot of documents. Jen Carby takes up a whole page. Okay, let's do 436 and remind us, we walked through this very early on, pretty fast, but walk us through what's in this one.
Would it be the most useful for the committee if I pulled up this section by section and shared that on my screen? Okay, great. Just a moment. Great. So you can find the section by section under my name. So it's for H436 miscellaneous tax bill. We did a walkthrough, I believe, possibly a month ago at this point. So I will try and give you a little bit of background, and please stop me. I can't see you because I am using my iPad, so I can only see my screen. So the first section, the first two sections amend the same section of statute, but slightly different issues. So this is in the meals and rooms tax. It changes definitions relating to meal delivery apps, and it adds a new definition of taxable meal facilitators. So these are your typically meal delivery apps. They will be considered operators like other operators, restaurants that are liable for collecting and remitting meals tax. And it clarifies that any delivery or facilitator charge that these facilitators charge will be subject to meals and rooms tax. So this is really getting at a similar issue to a few years ago with the online travel agents, just clarifying what charges are considered taxable. So I'm just going to pause there again. I apologize, I can't see you, so I don't know if anyone has questions.
I can't either, so you'll have to holler.
Ms. Shepherd, Chris Bragg, the question I have is this, I just want to make sure we're not sort of piling on. Is this the taxes on the additional value that's ascribed to the delivery service on top of the meal?
Yes, that's correct. So it's adding in both a new definition, taxable meal facilitator, and it adds into the definition of taxable meal, so the tax base, delivery or other facilitator charge.
Okay, so it's the margin between, okay, got it. Thank you.
Yes. And it also adds in taxable meal facilitators are considered operators. So they're subject to all of the same remittance, all the reporting requirements. They do have to collect tax. So when you think about it and conceptually, the tax is on the consumer, and that's who the consumer is most likely paying, is this delivery app.
Thank you.
Okay.
Great. So
any other questions?
Sorry.
No, I'm not hearing any.
The next section, section 2 of the bill, amends again the same section of statute, but in a different subdivision. Within taxable meals, there is a list of circumstances under which sales under current law of food or beverage are exempt from meals tax. The changes in H436 adds in alcoholic beverages. So when alcoholic beverages are sold under those circumstances, they will also be exempt. The primary circumstance where this would come up, where alcoholic beverages would be sold, are primarily by nonprofits. So this will allow those sales to go tax exempt. This was brought up, there was confusion over whether alcoholic beverages were allowed the exemption or not, and this clarifies that they are not. Currently, the information that the tax department had given was that they would be taxable. So this is a change to statute, but it's not clear that this was always the case for particular nonprofit organizations that were selling alcoholic beverages along with taxable meals, which were being exempt under these subdivisions. So again, I'll just pause.
Questions on that one?
Just a quick one. So when the local hospital fundraiser happens and it's a meal plus there's a bar there, are there taxes applied to the meal? Are there taxes applied to the bar going forward?
So I'm just scrolling through. If they were already, if the meals, the food or beverage being sold was already exempt, then now going forward, alcoholic beverages would also be exempt. And I'm just trying to see if there is an explicit exemption for hospitals. I don't believe there
Okay,
is.
I
Well,
think,
that's okay. I just wanted to make sure I understood.
all right, last year, the year before, this was a major discussion. There was a proposal that right now, if the fire department or the hospital has a dinner at fire department or the hospital, or they rent a hall. All right. It's tax exempt. The bill wanted if they contracted at a resort where the food would nominally be taxable. They wanted to make those meals tax exempt. And there was concern here about expanding that, and that didn't go through. So I'm not sure if the hospital is at a downtown restaurant doing a dinner that they're exempt. It's something to check on. But I know that issue came up, I think 2 years ago. Actually, it's come up twice.
That's
correct. This does not expand any of the existing exemptions. It just treats alcoholic beverage sales the same as food or beverage.
So if they're selling beer and wine at the fire station and the meal is exempt, then it would be exempt.
Correct. And I can share a little more clarity, because there are two different exemptions for nonprofits. One is when it's served or furnished on the premises, which is what you were just getting at, Madam Chair, with it being served elsewhere. And then there's an additional exemption, for example, fairs, picnics, field days. But there's a time limitation. It has to be less than 4 days. So that is in the bill language. It's all of these exemptions are listed out, but I could send it.
Yeah. So it's not if you have your local hotel serve a dinner for it's more limited than that.
Yes. I will draft a summary and share that with the committee to summarize the treatment for nonprofits.
Does the Madam Chair,
Yes, Senator McDonald.
the fire departments, churches, whatever, have dinners, they raise some money, they cook the food themselves, et cetera, et cetera. If the whole thing is catered, how does that work? And then the caterers serve the food and do everything, and the local organization doesn't roll up its sleeves. Is that taxed or not taxed?
I would want to confirm that, but it needs to be sold by the nonprofit organization. So I would want to think about that a little bit more before I give you a definitive answer.
I have a feeling it isn't, but it is taxable. This doesn't change any of that. It just says if now the food is tax exempt, then if the fire department, they'd have to get somebody's catering permit or have one themselves to sell beer or wine or hard alcohol, that would also be tax, or Coca-Cola, I guess, would also be tax exempt. And whether it's catered or not, this isn't changing.
No,
I'm very sure. Thank you.
This does not change any of the scope of any of the existing exemptions.
Okay, let's keep moving.
So the next section, and again, I didn't actually provide where these requests had come from. Both of these were proposed by the Department of Taxes under the Meals and Rooms tax.
Okay.
The third section, getting into education property tax and property tax credit forms. This was also proposed by both the department and the taxpayer advocate. This allows claimants who are changing any error that they've made on their property tax credit claim form currently cannot be amended except for the amount of household income. This expands what individuals can amend on their forms. So it won't just be household income. They can also amend house site value. Apparently that's a common a common error that individuals make, particularly where they confuse their equity in the home as opposed to, or sorry, that's the ownership percentage. They get confused about whether they are actually the 100% owner or, whether how much equity they actually have in their home, as well as both the state property tax and the municipal tax. So this expands that. I know, I believe Senator Sorokin, you had a question about this with the first walkthrough, whether it would potentially be, whether you might want to expand this to allow any errors to be corrected. Just wanted to flag that for the committee.
Okay. Keep going.
Yeah.
All right.
Oh. I'm sorry, was there a question? No.
I'm not hearing one. I keep hearing like somebody starting to speak. We'll keep going. If someone does have a question, just chime up. All I can see right now is the chart.
Great. Okay, the next 4 sections, sections 4 through 8. Again, this was a request by the department to update the statutes relating to payment methods that the commissioner can accept. It allows the commissioner to accept all payment types that are deemed necessary to effectively administer taxes. This conforms to the department's current treatment and policy to accept payments by checks, ACH, and it does some, actually the reason there are so many sections that are listed in the language is because method of payment is listed in a few different tax types. So income tax, estate tax, meals and rooms tax, and sales tax. If there aren't any questions, I'll move on to the next 2 sections.
Okay, let's keep going.
The next 2 sections are relating to current use, sections 9 and 10. This was actually an error that I had noticed going through the statutes, that there was confusion at the very end of the year in 2019, where a section of statute was repealed inadvertently. The section that was intended to be repealed was the fee section. I have it listed here at section 3777 of Title 32. Inadvertently, section 3757 subsection F was repealed, effective 1 year later. Unfortunately, that has now passed. That was repealed July 1st last year. So what you see in this language, it's all underlined, so it looks like it's all new, but really it's just adding back the language in subsection F that was removed. It has to do with when an owner applies for current use and their land is enrolled. This was again in 2019, a contingent lien rather than a full lien is placed on the land. The intention was to create a contingent lien and to remove the fee from when it used to be a full lien. So this cleans up that 2019 error in when the act was actually put into statute, when it was actually codified. Pause there again for any questions.
Any questions at this point? I am not hearing any.
Great. Section 11 is creating a statutory purpose in the sales and use tax chapter. There was an exemption created for sales of recyclable paper carryout bags last year at the end of the session. And in order to continue to have that exemption, which is considered a tax expenditure, to be enforceable, it does need to have a statutory purpose. So this is cleanup. To add in the purpose, it states that the statutory purpose of the exemption for recyclable paper carryout bags is to lessen the cost of those bags that are incidental to other retail purchases made by customers in Vermont. So again, it doesn't create a new exemption. It's just adding in a statutory purpose for that.
So when Joint Fiscal does their review of this tax exemption or tax expenditure, they will be able to tell us if it's doing what we intended it to do.
Correct. There is that biennial review. done by JFO. And that will, actually, I don't know if Graham's here, if that was included in this most recent one or not. But you will see that in the future.
It was not.
It wasn't this year. Okay. Actually, downtown tax credit was this year. Okay.
We're getting close to the end. We're getting into, and I apologize, that was also something, the statutory purpose was something that I recommended including, just as part of our review of statutes, recommended that go in. For the next few sections that you have here, this is where the bill gets quite miscellaneous. These were not requests from the department. These came through the Ways and Means Committee as they were reviewing the bill and had other requests. So the town clerk recording fees, to start that, I believe has been proposed as a bill several times over the last biennium, when the town clerk fees were added into statute and then they were increased. I believe 2 years ago, 3 fees were not increased, and 1 was not decreased. So this sets everything at $15. These are fees and costs allowed after the warrant and levy for delinquent taxes have been recorded. So it increases recording the levy and extending a warrant from $10 to $15, making a return and recording the return from $10 to $15, and it actually reduces the recording of a collector's deed from $30 to $15. Don't know if there are any questions there. I know you are having.
I'm not hearing any. Okay.
Great. So I apologize. I said these were all not requests from the tax department, but the next one was a request from the administration. My understanding is this was built into the budget as proposed by the administration. These are 2 healthcare related extensions of repeals. There is the home health agency assessment that is set to be repealed this July. This language extends that repeal for an additional 2 years. The same is done for the health IT fund allocation. It's a different tax as the healthcare claims tax. It's put into this IT fund. That allocation would be sunset this July 1st. It's extended an additional 2 years. And these 2 are often and have historically over the last few biennium been pushed back like this by 2 years. Okay.
Madam Chair,
Well then, all right, Senator Bray. Did you?
Yeah, just a quick question. Does anyone here know what that health IT fund, what the revenues are annually? If not, let's keep going, but I just trying to have a sense of scale.
I can ask Nolan Langwell I assume that he has all of that. I believe is coming in tomorrow to give you more information about this.
So we're going to go through these section by section in detail.
Okay.
With witnesses starting the next 2 days.
Thank you.
Great fun.
Okay.
Yes, Madam Chair.
Nope, keep going. I haven't heard anyone.
Section 15 was requested by the Attorney General's office to align deadlines for manufacturers, drug manufacturers, when they report and pay fees to the AGO. Currently, those are for allowable expenditures or gifts. Currently, they have to pay before they've reported. And with the pandemic, it was creating issues where the individual who issued checks, so a pharmaceutical company would pay their fee just out of an abundance of caution, and then find out in April they actually didn't owe the fee, so they'd request a refund. And an individual had to go into the Attorney General's office to issue a refund check. And this was happening quite frequently. So they requested to just align the dates so that both the reporting and the payment is due at the same time.
Okay. Questions? Okay. One more, I think.
So the next is, there are a few more. Well, there's the workers' compensation rate, and then there are the effective dates. The workers' compensation rate is being unchanged from the current year. So the fiscal year 22 rate will be 1.4% for workers' comp insurance premiums and 1% for self-insured workers' comp losses. And this was requested by the Department of Labor. And I believe they're coming in tomorrow and they can.
Yeah,
provide-
that we do that, I think, every year. So
yes,
another standard thing. Okay. And then we've just got effective dates.
yes, there are some retroactive and prospective effective dates in here, as there typically are in the miscellaneous tax bill. The taxable meal, so the delivery apps, is taking effect a month later. The default effective date is July 1st, but this the affected taxpayers, the meal facilitators, asked for an additional month just to adjust their systems before they begin collecting. The alcoholic beverages tax, because that is allowing an exemption, it is taking effect retroactively on April 1st. So any sales made on April 1st or after will be exempt from alcoholic beverages tax. And lastly, the current use cleanup and the statutory purpose both take effect on July 1st, so that there's no break in time, particularly for the current use lien and subordination fee that will continue as though it were never repealed. And the statutory purpose will be in effect at the time that the exemption actually took effect.
Any questions at this point? We're going to be going into detail on these and then all the other things we've talked about adding. Senator Bray.
Was there any consequence to that oops on use value? Like, did something happen to anyone that has to get undone?
Not to my knowledge. I do understand that the Bankers Association, I believe, is coming in to speak to this tomorrow. They might be able to answer that.
Thank you.
Okay. Further questions, discussions. All right. Committee, I don't know about you, but we're 7 minutes late. Would you be more effective if we went through the new 360 or take a 5-minute break so you can stretch a little bit? 5 minutes? Okay, let's take a 5-minute break. Shut off your video and your audio because we're not getting off live because we may never get live again. So we'll just be out for 5 minutes. All right, is anybody back? Maria's back. Mark is here, Ruth is here. I need Senator Pearson and Brock. Okay, Senator Brock is here. Means we're waiting for Senator Pearson, but I think, oh, he's here. Okay. So Maria, want to put this up on the screen and let's walk us through it? Hopefully.
I sure will. I sure will. Faith, if you could make me co-host. Great. So this is draft 1.2 of your proposed strike all amendment. And I realize time is of the essence. So I'm going to tell you, I'm going to start by just clarifying what's not in here. I deleted the provisions that I think you said, the sections that you don't want to include, which were essentially the 4 sections that had to do with the Vermont Universal Service Fund. The 0.4%, transferring it to the operations of, this is in the House bill, to their authority, and then making amendments to the connectivity initiative. I believe the committee decided at this point not to make changes there. So for the time being, existing statute is going to remain unchanged. So then going through what is new language I've highlighted, and the first one is in the findings section. I believe there was agreement that you would have one new finding, which is number 18, that specifies, in addition to broadband access, it is imperative for the state to address the critical issues of broadband affordability and adoption. Then moving on from there, this is in the purpose to the chapter. I think you wanted to incorporate some language that was in H360 as their purpose, and that's what you can see highlighted in yellow on your screen. So the overall purpose is to establish the fund and to establish the Vermont Community Broadband Board to coordinate, facilitate, support, and accelerate the development and implementation of universal community broadband solutions. There are no changes in the definitions, in the fund, the management of the fund. This is not a change. This is the executive director. I just inadvertently forgot to take out the highlighting. So then scrolling down, I took out the provisions that were specific to the pre-construction and the construction grant programs, the interim spending, and combine them into one section in session law, which we'll get to in just a moment. But before that, there was a suggestion from Senator Pearson This is the provision that specifies that before the board awards a construction grant to a provider who is not a CUD, the board shall make a reasonable effort to determine that the carrier's plan, et cetera. So it had said before, small communications carrier, which in a sense is under the definition of eligible provider, not a CUD, but I think this is, says the same thing and is very clear.
Let me ask a question there, Maria, just about that overall subject. Is it correct that we have now concluded that for any small communications provider to participate in funding, they have to agree to universal service throughout their area? And one of my questions is, what does that area mean?
So what they're agreeing to is providing, so let's just go back to the beginning of for example, the construction grant program. So the purpose of the program is to finance the broadband projects of eligible providers that are part of a universal service plan. So the universal service plan is 100-100 to all unserved and underserved in the service territory, for example, of a small communications provider.
So that service territory, for example, let's use Franklin Telephone as an example. They are the exclusive carrier as of right now in Franklin, but they also serve locations in Highgate and Sheldon that are part of the Northwestern CUD. So what is their service territory? How would it be defined? Would it be all of the 3 towns, or would be in the areas that they currently serve? How would you define that?
I think there might be some discretion here. So if they are serving, their area extends into a CUD. So if they're building, so their service territory is their service territory.
Well, you could argue
and
that
that's
it extended into their territory, but that's a semantic difference.
Well, yeah, I suppose it is, but so there'll be some discretion, I think, for the board to look at, do they have, are they getting the funding to build out their entire service territory? Or is the CUD building out some of those locations? I think that's something that the board is going to have to look at. But I think their service territory includes, that's already set. That's where they're required to provide voice service to all locations. If those areas are going to be served by a CUD, then they're no longer unserved and underserved areas.
Well, the question I'm thinking of is, in effect, the veto power of their expansion. That's the concern I have, is essentially the board has the veto power now to constrain where they go, even if they're going and operating in areas in which they have already, prior to the existence of CUDs, operated. Are we putting a constraint on these enterprises?
Well, I think your point is well taken, and I think that's a policy decision about whether you.
Madam Chair.
Yes, Senator Bray.
So I'm just trying to understand the use of the word constraint there. This is for applying for grants for expansion, right?
Well, it's also, yes, it's principally for applying for grants for expansion. That's correct.
Okay, I'm going to ask that we move on. We are not going to solve every possible issue. I think Franklin Telephone had all but 9 miles with 2 residences on it wired.
That was in Franklin, but they're operating, as I say, they're operating in multiple towns, and I'm just concerned about constraints that are being placed.
Well, I think we have to leave it to the board to decide whether or not Franklin's going to get, the purpose of this is to stop anybody from coming in and just doing downtown and leaving the whole circle around it for the CUDs to do. And I think we're just going to have to trust that the board can make a rational decision. We could sit here and speculate on individual cases till 10 o'clock tonight. But we don't have that, at least I don't want to have that much time. And I think we've done as much as we can to clarify what we intend.
Right. Madam Chair.
Yes, Senator Pearson.
I agree. And I would just say, you know, the House's construct, Senator Brock, was entirely through the CUD. So
I
they
know.
only get a contract through the CUD. Now, our construct allows them to do that, or allows them in their own right to reach an agreement where the CUD tells the board, no, we're not threatened by that, or in their own territory it's not covered by a CUD, take the grant directly, or use their own money to expand as they see fit. So I mean, we've certainly given them more options than the bill that came over, and I agree with the chair. We have attempted to address most of the scenarios.
And we've worked hard on constructing a capable board that would be able to discern one, sort of a good instance from a bad instance, I might think.
And you can always join with the CUD, let them apply for the grant and contract with you to string the cable or fiber or whatever we're calling it. Okay.
Okay, so then the next change, so this has to do with the positions that are hired by the department and then overseen by the board or the executive director. So we'll just read through this because most of this is new language. There was one provision in H360 that I don't think that I had actually stricken, but I don't think that was the intent. I didn't realize until after I went back and looked at it a little more further. With respect to the existing rural broadband technical assistance specialist, that is currently a classified service position. And that was specified in the House bill and session law. So I don't think it was your intention to change that. So you did put that position under the direction of the executive director in the statute, but you didn't specify there that it was a classified service position. So that is done here, but also what this includes is some transitional language. So that position shall be subject to the oversight and management of the executive director upon his or her appointment. So as you know, that's an existing position. The duties will be carried out. But then once the executive director is appointed, that's when they would be subject to the oversight of the executive director. But then subsection B, this concerns the commissioner's ability that we talked about earlier to hire staff immediately. So the language that was in the statute has been stricken, and now it's here in session law. And we'll just go through this to make sure it's consistent with what your intent was. So the commissioner is authorized to hire one full-time employee to provide administrative services for the board. This position shall be a limited service position that is part of the classified service. The commissioner is authorized to hire one full-time attorney to provide legal services for the board. This position shall be an exempt position and shall be subject to the oversight and management of the executive director of the board upon his or her appointment. And then this is language that you had looked at before, just that the salaries and benefits for these two positions come out of the fund. These are considered operational expenses that can be reimbursed from the fund. And I'll just clarify, just to be perfectly clear, the existing rural broadband technical assistance specialist will continue to be funded out of the Vermont Universal Service Fund. So that language remains in statute. That funding source will continue for that position. So hopefully this is consistent
Maria,
with what you were, yeah.
The other language about the executive director being able to hire an additional 3 FTEs, does that remain in the bill? Is that?
Yes.
That's in a separate part though.
That's in statute. Yep. I did not change that at all. The only change in the statute was related to, remember there was that language that the board could rely on the department for legal and administrative support. I took out the legal so that that's not ongoing in statute. But that they will still continue to have an administrative position. And then that legal position will work for the commissioner until the executive director is appointed. Does that make sense?
Yeah, I think so. The administrative person though is hired, the commissioner is authorized to hire 1 full-time employee to provide that would be a limited term position, even though the requirement to provide administrative services is ongoing.
May
I suggest we just,
that could convert to a permanent position. That is a good point, and I'm not sure if the proposal there, I'm not sure if that was because the commissioner was thinking they needed just the support, and I honestly don't know.
may I suggest we peg it to the timeline we've created for the board, which, let's face it, we will extend at some point, but at least they hinge together.
And that may be why it's limited service, because it's not guaranteed that it's going to go on beyond the time that the board goes on.
The board is till 2029. So, okay.
Okay, so I will make that change. Board. Okay. So
Otherwise,
then,
I think it looks good, Maria.
okay, I know, gosh, it's always something. So then, in terms of the authority for the department to do some interim awarding of grants, again, taken out of the statutory sections and now put into session law. But I think what you ultimately decided is to give the discretion to award up to $20 million. But we'll just read through this and make sure it makes sense. Notwithstanding any other provision of law to the contrary, to ensure the expeditious disbursement of available funds prior to the organization of the board, the department is authorized to allocate and disperse up to a total of $20 million or up to $25 million if an additional $5 million is approved by the Joint Fiscal Committee under the Broadband Pre-Construction Grant Program and the Broadband Construction Grant Program on or before December 31st of 2021 or until the board is operational, whichever occurs first.
Any questions, comments? Okay, looks good.
Okay, so then I don't think there are too many more changes. You looked at this language already. This was an amendment that Senator Bray proposed earlier today. There have been no changes, just folded it into here as a new section 19. And no changes here. These are just really notes for myself to make sure the cross references align with the section renumbering. So that is all I have that's new. Am I forgetting something?
I can't think of anything. Anybody else? Did we miss something? Okay, committee. I'm hesitant. My usual position is that I will let a bill sit over to the next day just to allow it time to percolate and all those emails to come in and tell us what the problems are. I'm a little leery of doing that on this one.
Madam Chair, I don't know if you can see me or not.
I can. I was just waiting till I finished to recognize you. And I also had Senator Pearson.
Okay. I'm sorry, I had to take a phone call, but I just wondered if we had talked about the net neutrality provision. I did do what people asked me to do and talk to Maria and Josh Diamond. Did we deal with that?
We have not talked about that today, so I assume it's the same as it was yesterday. Maria, can you find that section for us? Oh, you're muted.
That hasn't been changed, so it's still in the bill as a priority. Do you want to go back and look at that language?
What do you want to change, Senator?
So, Madam Chair, to make things simple for the purposes of moving this along, after talking to Josh Diamond, I think we can do better than make this a priority, but it is somewhat of a confusing issue. Maria can try and explain it to you because she's been in the loop as well. But what I would ask is that if we pass it as a priority, as this bill goes to conference, we continue to explore our options to make a stronger statement on net neutrality. And if it is comfortable to all the conferees, we don't hold fast on this position.
I think that we'd all like to do as much as we can without risking legal consequences. So I don't think there's any, it's in here, so it's subject to discussion. Is it in the House bill?
No.
I don't think so. Okay. So that will be a viable topic of discussion.
And just so I'm clear, Senator Sorokin, you're saying if we feel comfortable that we could bump it up from a priority to a requirement?
That would be my hope. And I personally don't believe there's any downside to doing that, but I think it needs some more discussion.
Okay, thanks. I like that myself.
Yeah, I've seen bills go down because of threat of lawsuit and costs. So I don't want to risk this. It's too important. Senator Bray.
Are you looking for a motion yet, Madam Chair?
Well, that's what I'm deciding. If we are comfortable, this has been well hashed out. We haven't made any real changes. I am comfortable to vote, or we can meet at 9 o'clock tomorrow to vote.
I believe Abby is meeting in the morning.
Pardon?
I believe my morning committee needs to meet at 9, unfortunately.
I was told that no one met without my permission.
Right.
Well, that may be. We do have a bill that's come back is the issue, but I could.
Okay. We can vote now if you are ready. So Senator Bray.
So, Madam Chair, I would move that we amend Bill H360 as provided for in draft 1.2 timestamp 227. with
Okay.
today's date.
Motion to amend, which is the final amendment we just went over. Actually, it's to amend with a strike all, right? This is a strike all, so
Yes.
it's a total amendment. All right.
Maria, was there going to be some tiny change though, I think?
Yeah, subject to the one change about the limited service administrative position, that you're going to tie that to the life of the board. So I can just strike limited service. Maybe that's the easiest thing to do. Is everyone okay with that if I do that?
That right now, and then that's what we're voting on?
Yeah, I think that works too. Okay. It's easier.
Okay. Further discussion with that Scribner's correction? If not, this is the motion to amend. So all those in favor say aye.
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 That is 7-0-0. Okay, we now need a motion to approve. Senator Bray.
I would move that we report out favorably H360 as amended.
Motion to report favorably as amended. Is there further discussion? If not, all those in favor say aye.
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 Carry 7-0-0. I'm going to put myself as the reporter. My intention is, because this is such a long bill, to divide up. I don't know if I can lodge. I am too tired at this moment to, maybe not, figure out dividing it. We've got to see if we can find 6 sections. But I think we might do better if we were awake. But my intention is to have all or most of you report a section of this bill, because it is a committee bill. And it's taken a lot of committee hard work. So we'll do that. I don't know. Maybe we could. I'll look at it tonight and see if I can find it and take a look at it, and let me know if you're interested in any particular section to report, or if you are overwhelmed with your other committee with reports. Senator Sirotkin, I know you've got a big committee, and I've been demurring on reporting health and welfare bills. So let me know if anybody doesn't want to do a section, and I'll get this put together for tomorrow. And we will let Secretary Bloomer know that we have passed this out. Maria, have you got a clean copy you can send
I'll send you
up?
one in about 5 minutes.
That sounds good. Okay, committee, thank you. This has been hard work. There's light at the end of the tunnel. We've only got about 10 more bills to get out, but we'll knock several of them out a day. We'll be out of here. Once we do miscellaneous tax, that takes up most of the bills we've got left. And then we've just got a few minor ones. Senator Hardy.
Madam Chair, you asked me to remind you about the appointments. And I have one I'm ready on.
Okay, yes, that's right. I was saying I need to pass out appointments so that people can call them. These are not, yours is one that's going on the calendar to be reported. The rest of them are not. We just need to get them on the calendar before the end of the session so they can be done in bulk. And I'll get those out tomorrow too. So Senator, the floor is yours.
Okay. So back in early March, I was assigned to talk with Margaret Cheney, who is up for reappointment to the Public Utilities Commission board. And I did over our March break, which seems like eons and eons ago. We had a very nice conversation. I don't have her bio in front of me, but I'm certain that you all know who she is. And she's a former House member, was chair of the Energy and Tech, or vice chair of the Energy and Technology Committee. And she is up for reappointment to her second term on the commission. She's a lovely person and she's extremely knowledgeable about the area. And we had a lot of conversation about her sort of opinion that the work of the POC is really related to the work of reducing climate change and carbon emissions in Vermont. And I thought that was really interesting. So I'm happy to answer questions or get more detailed information about her bio if you're interested in it. But I would recommend approval of her for reappointment.
She was also very instrumental when we, several years ago, did a study on how to make the PUC process more user-friendly to the average citizen. And she headed up that effort and helped us change it from a lawyer versus lawyer to helping the general public have more access to the board, so the commission.
Yeah, she did mention that. You're right, Madam Chair. And she was very much interested in making sure the process was smooth. She had a lot of really great things to say about the staff and the professionalism of the work that they do. So I learned a lot by talking to her for an hour.
Okay, that is a motion to approve Margaret Cheney to the position on the Public Utility Commission. Is there further discussion? If not, all those in favor say aye.
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 Opposed? Hearing no opposition, Senator Hardy, you can be the reporter and we'll get that all up to Secretary Bloomer and then we're done for the day.
So soon.
So soon. I know, it's not 6 o'clock yet.
Yep.
So hopefully it will be a little less intense from now on, but no guarantees. Okay, thank you. And I'll get this stuff up as soon as Maria gets it to me.
I would expect that we'll still have to go to finance, even though the money's covered in the budget.
We are finance, Senator Peterson.
I'm sorry, appropriation. I would think just in terms of floor timing.
I don't know.
Well,
Because
I would.
Yeah, well, we'll
It was already in the budget.
we'll see. They appropriated the money.
Yeah, right. That may be the reason.
Only Bloomer understands Rule 31.
I would just say, it may not.
Yeah, it may not until we find out. Well, we should, I get it up to them today, if they're still there. They probably are. It should be on notice tomorrow. And then tomorrow is Thursday, up on Friday, or it'll go to a PROPS. It'll be up on Tuesday. It would actually probably be better to be up on Tuesday because that would give everybody time to clear their minds and prep. So we will see where it goes.
You could reread it for the next hour and a half and then.
I could, or I could
Go
put
ahead.
it in my pocket and not report it till tomorrow morning, which is somewhat of a tradition, but we'll see where it goes. Okay.
Senator Cummings, I already let the secretary know that we voted the bill out. I apologize.
Rats, too much efficiency. Okay. So he is waiting. So you can all leave. I will wait for Maria to get me a clean copy and then I'll get it upstairs. And tomorrow at 9 o'clock, I'll sit down with this bill and see if I can find 6 or 7 easy pieces. I think we've got at least enough sections so everyone can do a section unless someone lets me know they don't want to. So,
I'm guessing the Senate Secretary's there because tomorrow's calendar's not up yet either.
okay, yeah, he's waiting. So let me find my emails.
Senator, are you ready to end live stream?
I am ready to end live stream. Yes, it's probably now safe to end live